7-2 DP Dickerson versus Vernon. Both parties are present via Zoom. There's a motion for change of custody filed by Mr. Dickerson that I'm not even sure that I fully understand. He says read his daughter's diary and has his daughter having some kind of relationships with a cousin that moved out of town or sisters, or I really don't know. Has CPS been involved with this case?
No.
Police or anything?
No.
Sir, what? And I understand you've been keeping your daughter out of school, which is completely unacceptable. What do you have to say, sir? You say there's somebody who won't disclose their name, gave you information. What am I supposed to do on something like that?
They asked me not to say their names, so I told them I wouldn't say their names.
Well, I understand, but you realize that you can't come into court and say somebody told me this, and the other side has a right to know who's making the accusations and stuff. I'm not going to be able to do anything. I don't. What are you asking for? You said the person who she was supposed to be with or something has left and gone back to another state or something.
There was a complication at one time with the letter about my daughter were inside of her diary, and I had brought to her mother's attention, and me and my girlfriend asked her to get her into counseling for it. And I thought it was because when I first heard about it, it wasn't about my daughter. It was my daughter wrote something, and it was her cousins being touched or something, and it was happening at her grandma's house, Laquita's grandmother's house. And I brought it up to her attention to try to get stuff to help out for her. And I thought that was the only altercation until this person told me that this has been going on.
But I can't base anything on some person that I don't even know, that she doesn't even know, says something else has been going on. That's just what am I supposed to do? If everybody came in and said, really, somebody told me that this happened, and I want custody, that would be Miss Dickerson. What have you got to respond?
There was an incident that happened at my grandmother's house, and Rico did bring it to my attention, and I also bring it to my grandmother's attention. We all sat down and got it all under control. It only happened that one time, and she wrote it in her diary and he brought it to us. We sat down and we all talked about it. We settled it out. The second,
that's how it's supposed to work.
Exactly. The second time,
if your daughter needs some counseling, then you need to get her to some counseling too. I mean,
yes, I did do that, and I went to the school, and she goes to counseling in school with her teachers. She does an hour a day, and she's going to Net 180.
It sounds like it solves the problem, sir. There's nothing in here that provides the VARCA standard of change of circumstance or proper cause. There's nothing that the mother has done that's not appropriate. The only thing that I find inappropriate is it seems like you're keeping your child out of school
and away from me, Your Honor.
Yeah, there isn't. Well, he just signed off, or did you? He just left.
Yes, I have not been able to be in contact with my daughter at all since he took her from school.
Well, he just logged off because he apparently doesn't like what I'm saying. But quite frankly, you're entitled to your daughter. If nothing else comes, I would consider coming in and for an ex parte order through Judge Hillary for the return of your child immediately. All
righty. Well, may I be able to do that today?
Probably. I can't speak for him, but I'm just telling you, there is nothing to indicate that your daughter should be remaining with him.
Okay, thank you, Your Honor.
Violating the court order.
I'm sorry, can you repeat that?
I said he's violating the court order of custody.
We don't have a custody agreement. He just pays child support. That is it. We don't have a custody agreement, and he's not on her birth certificate.
He's not on her birth certificate. It doesn't matter. It's there. He was adjudicated as paternity. He was found to be the father. And I'm guessing that's an order that gave you custody. I'm looking for it right now. But there would likely be an order. It was signed at the time custody was granted, or that he was found to be the father. Because they don't do these things different.
Okay.
Let me just see if I can. I'm sure, genetic test results were provided that showed that he was the father.
Yes.
Then
Yeah.
Then a child support order was entered, as was, there's so much, on June 10, 2015, there's a judgment of paternity. All right, send them in. That says that you shall have the physical custody of the minor child until further order of the court.
Yes.
I'm sorry, my phone had, I don't know what happened.
All right, I'm just telling the mother that, she has custody in the order of June 10, 2015, all right? And
There
so
was never, I don't remember no custody agreement. We only had a child support agreement.
it doesn't, I got it right here. It's a court order. It's a court order. I'm reading from it right now, and it's,
How come when county clerk told me there was no judgment for that?
I'm looking right at the order. It's signed by Judge Patrick Hillary on June 10, 2016. And the order says that shall have physical custody of the minor child until further order of the court.
When I went to the county clerk, they told me there was no order of custody. It was just the order of child support.
Well, I'm telling you that I see.
I know what you're saying. I'm just telling you that's what they told me.
That might have been what they told you, but they were wrong. That she does, and you both signed this order. You both signed it back on 6/10/16. There's your signature and her signature and the judge's signature. And it is a judgment of paternity that gives her physical custody. There is also a June 10 order of uniform child support. I agree with that, but that was signed by the two of you on 6/10 and same with Judge Hillary. There were two separate orders entered.
Okay, so we need to change it.
I mean, you can come down and look at it, but she has custody, and for you to fail to return the child, the judge will give an order to allow her to come pick up the child. She has to be returned.
There's not a way you can change it.
There is not Vadvarka anything to have a change of custody hearing. So the two of you need to sit down and do a parenting time agreement or something, but she has custody. I'm reading it right here. So
what am I supposed to do about what I was told? Like this.
What do you mean about what you were told?
Okay, so what am I supposed to do now?
Return the child.
Okay, I know that much, but did you even read what I put in my paperwork?
I read it in there.
Going on in the house, all of them, even all the evidence I put in. You read all of that.
What do you mean all the evidence? You did a 1-page document here saying all this stuff, and then there were some documents with it.
There's documents here.
What is that supposed to do?
It's showing you the proof of why I did what I did.
That's fine. You did what you did, but you don't have sufficient evidence to change custody.
So what's going on? Don't matter.
There has to be a Vadvarka finding, and I don't find it. Everything was taken care of when something happened with the daughter. Everything was taken care of appropriately.
Yeah, that just happened like a week ago. I asked her to do this 2 months ago, and then she's keeping things from me about my child. And all this paperwork stating, I could tell you who the fuck wrote it. I skipped it off. It was her sister that told me this shit.
And you can quit swearing on the record any time now.
Okay, there's just sexual
abuse. Stop. Just stop.
I have to follow the law. Okay. And that's all there is to it. I don't find you have to provide Vadvarka standards, change of circumstance or proper cause. And it has to be shown to a certain level. And the fact that you read a diary a while ago and everything seems to have been taken care of. There's no police reports. There's no CPS reports or anything. If you wish to, I'll do an order. If you wanted to vote up to the judge, you can do it. But there just isn't anything here to change custody on. And even if there was, you still have to send the child back because I can't change custody on a Friday morning. I have to have an evidentiary hearing, which will be set out a couple months from now.
So you're saying I would take my child back to a place where she's been doing sexual things with her sisters, and it shows on this paperwork that it's been kept and happened, even said by her mother in the evidence.
What are you saying is the evidence?
This all the paperwork that I sent you, all the
paperwork you sent me to begin with has no dates on it. Nothing. All right, I just got a bunch of stuff here.
August 17th. August
Okay,
17th. I don't know how you
what
don't-
about the other page
Address.
here and the other
Or
page here that
dates. I
I'm
don't think I
reading?
know dates while I'm looking here.
There's, you know, I'm going on,
Date and time.
I'm going on 9/40, it tells me, but doesn't tell me what date. All this kind of stuff. There's nothing of substance on here. It's just page after page of stuff that has no valid dates to it, nothing for me to follow through, nothing. It's just a bunch of stuff. I got an August 26th date for one thing. Okay? August 17th. That's way back. All right, that's way back in August when you talked about this before. So I'm denying your motion for custody. She will get the child back. If you wish to try and figure out something, you should go to an attorney because you're way out of your league. You're not following what needs to be done.
Not my child is not safe. How am I not following what's not to be done?
Thank you. I'm issuing the order. We are adjourned.
I'm just.
Thank you.
Thank you, ma'am. Drolema versus Drolema. Both parties are present. Mr. Drolema through his attorney, Katie Steffes. This is the father's request. Says custody or parenting time. Says kids were kicked out of mom's house in August and have been living essentially full time with dad. And so wants a potential change of custody. Ms. Steffes, anything you want to add to that briefly before I hear from Ms. Johnson?
No, not really anything more that I have to add before you go to Ms. Johnson. I might reserve some time to respond to what she says, but
Ms. Johnson, I mean, your response, it seems to be that you're having some problems with the children and they aren't respecting you and you sent them to dad for a period of time. What do you got to say, Ms. Johnson?
Yes, we didn't kick them out. They were trying to get me to sign a paper for a while that they want to live with their dad full time because then they can play basketball, travel basketball, and they have the ability to do things that they weren't able to do here.
Did you sell their moped?
Yes. Well, one of them, yes.
So what do you want?
I just want them to come back here and respect us. I mean, it was just an issue of Carter getting out of hand. I mean, he was becoming verbally and physically abusive towards me, and we had an incident, and we were just told them that they needed to respect our house and if they wanted to stay here, and then they were working out some sort of deal with Scott behindhand to come pick them up, and so they
But it appears that you didn't really go back to get them or anything like that. They've been living there for September, October. Wouldn't you agree?
Yeah, I mean, I did try to get them, and they ride the bus home, so they just didn't get on the bus. He came to pick them up, so they went with him.
Ms. Steffes?
I've heard this explanation by way of Miss Johnson's former attorney before. And I think the concern that I had is that I have heard the recording that happened between the stepfather and the party's son, and it's very concerning. I would not have thought that there would be enough to change, at least request to change custody, had that not transpired, in addition to telling the children that they needed to pack all of their stuff, go with their father back in August. They watched the children carry literally boxes of their belongings out of Miss Johnson's home, did not intervene. At that time, there was no communication with my client to ask for the children to be returned or that she did not want them to move out of the house. I think there's a lot going on behind the scenes here. And we would ask that this be referred to the Fred of the court to kind of vet through what all of this is going on.
How's that
Unless
going
Miss Johnson,
it's going to take a couple of months to go through them, and then
I know
neither of you are going to agree to it. And I'm going to have a custody hearing on this because there is potentially Vadvarka that's enough because the kids have been out of the house for 2 months, basically living with dad.
And if you prefer, I mean, we can just set it for an evidentiary hearing date. That would be fine, unless Miss Johnson would be, open to discussion with her either today on the record, if she's agreeable to letting them stay at Scott's primarily and then coming back every other weekend. She had indicated previously that she might be willing to do that. Obviously that's up to her.
All right. Let me ask her, ma'am, I believe there's enough, at least potentially what's called Vadvarka. It's proper cause of change of circumstance because there's a change of circumstance. The kids have been living with dad for a couple of months. all I would set is an evidentiary hearing, a custody hearing. I'm not gonna change custody today because I can't, all right? The question I would also have then is what should we do in the meantime until you have an evidentiary hearing, which could be 2 to 3, probably 3 to 4 months down the road. So I'm looking for something from you because it doesn't appear that the kids want to come with you, that they're, you've stated at one point, I think that you want to see them every other weekend or every weekend, or I don't know what. What can we do in the meantime? I just as soon not send it to the friend of the court, or do you guys want to go to mediation? Ms. Johnson, you interested in going to a mediator?
Yeah, I'm fine with that.
Ms. Steffes?
My client would be fine with that if the cost can be at least split. And right now he is.
That's what everybody has to do. I mean, I don't make one person pay it. Everybody's got to pay for that. And we can find that between the two of you can work out a mediator, get into that mediator and get into them now and see if you can figure something out, because the parties aren't doing too good at talking, but then I've had them in front of me. We're on file 4, so it's not like I'm unfamiliar with them.
Yes.
And they haven't had a lot of agreements throughout their time. So what do you want to do? You want to go to a mediator?
Well, right now I'm not working, so I wouldn't be able to pay for a mediator.
I think right now, maybe set it for an evidentiary
I'm
hearing.
going to set it for an evidentiary hearing. In the meantime, what should we do to make sure that the kids at least see the mother on a regular basis?
They're scared right now. They've told me they're scared to come over to our house because Scott, until we go to court. So maybe now that we've gone to court, maybe they're willing to come over here every other weekend. They're just scared because they're afraid they won't be able to play travel basketball. I mean, that's really what it comes down to.
Well, I would hope that the two of you would work together to allow them to play travel basketball. It's something that kids...
They played last year.
It's something that the kids earn, not the parents. I don't know how else to say it. So
I might suggest, can I just throw out an option that we do every other weekend to mom right now, pending the evidentiary hearing, and that the parties will work
school until Sunday
Sunday
at 8 o'clock, and one evening a week she can see him too.
Yes.
All
And
right,
that they will
after school
coordinate
play.
together with the children's sports and extracurricular schedules.
Yes, I want her to have every other weekend and at least every Wednesday night. You're not working, so I assume that's pretty easy, ma'am.
Yep.
From after school until 8 o'clock on Wednesday.
Yes, I will prepare an order to that effect.
Prepare that order. When's it going to start?
So he comes and picks them up at 8 o'clock on Wednesday?
You pick him up from school and he'll pick him up from you on Wednesday. You pick him up from school on Friday and he'll pick him up from 8 o'clock on Sunday. All right. All I'm asking is, when does it start? This weekend or next weekend?
Scott, is it a problem to have them start this weekend?
Keep it consistent. Next weekend is her weekend. Okay. And they plan on coming here today.
All right, then, but she will start Wednesday.
Yep.
Yes.
And then next weekend, and we'll go on from there. We'll set an evidentiary hearing. We'll notify you regarding that. I suggest that the parties spend some real time talking about this.
Yes.
To reach an agreement. Good luck, everyone. We're adjourned.
Thank you. Thank you, referee.
And we're going to all sing a little bit of Delta Dawn to my aging sister-in-law, who is down in Tennessee watching us. So could we all join in a little bit of Delta Dawn for her?
Are we ready?
Are we ready? Delta Dawn, what a flower you have. There you go, Missy. That's going to be about the best. You faded rose from days gone by. Not many people are going to ever get me to sing on. Gosh, we might go on forever now. Here we go. Looks like, I don't know. Yeah, his attorney, Ms. Cook, is on. Looks like he's now connecting. Ms. Cook, I understand your motion is that you need documents so you can transfer title of something that of a mobile home that was supposed to be given to your client to begin with. Is that my understanding?
That's accurate.
All right. And so did you serve the plaintiff? Because she's never been on or anything. Can you tell me what?
Sure. Yes, we sent it to her last known address. We have proof of service for that. We also attempted to have a process server just to see if we could, but he was not able to make service. And we've attempted phone contact. the closing office's attempted phone contact. The last contact that they had with her, she said she was in Iowa. She doesn't live in Iowa, but she said she was there. She didn't give any details. She's refused to contact anyone back. So we do have a proof of service showing that we sent it to her last known address. If she's moved, she hasn't informed anybody. She hasn't given that information to the closing office.
All right, it appears that you've done everything you can to serve her. So with that in mind, I will sign an order that you say you need. At least, I don't know what order you need. I think you sent one in. I think I got one late.
We did send the order in. We actually had this scheduled with the judge, and we had asked specifically for the judge because timeliness is of the essence. So I was a little surprised, not that we don't like seeing you, but we were.
Yeah, you do. I understand. I'm offended, but I'll deal with it.
Yeah, I don't think you are offended, but thanks for
He
giving me.
sends all post-judgment motions to me. Okay.
I know.
So I can sign the order and I
Yes.
can get it up to him for signature. I'm just trying to see if I have the order that you want signed.
Well, we sent it in with the motion, so it should have been. However, if there's an efficient way to get it to you, through email or some other mechanism, if you could tell us, otherwise I can have someone run it over to Kent County today.
Whew. That's certainly efficient, but if I can find it, great. Otherwise, can you email that here and we can print it off? If you can email it here to, who should she do that to? Normally I'd say Tracy Dewey, but what email address can she send it to?
Just, yeah, here. Are we gonna do
Whatever the order is that you need, if you can. Do you have an email address for Judge Hillary, or I mean his clerk or something?
No, sir.
All right. It's looking.
So is there a different one I can send it to?
Yeah.
The problem is my clerk is off today, so I can't give you my clerk. I'm trying to find somebody to get it to.
I'll give you my email. It's Michelle, Michelle.
Okay, I'm sorry, Michelle?
Correct.
Okay,
Dot Vidro, V as in Victor, ID as in dog, RO.
okay, I'm a little slow when it comes to spelling. Okay, Michelle dot, and is it Vicker?
VIDRO.
VIDIRO?
No, V like in Victor, VIDRO.
Got it. Thank you so much. Sorry for that.
That's all right. If you can send that, I'll do everything I can. If we have some problems with it, I'll have somebody contact your office.
All right, so it will need the referee's signature and then a signature line for Judge Hillary, correct?
Yes, that's correct. And if I can sign it today, I will try and get it to Judge Hillary. I don't know if he's here this afternoon or whatever, but I'll do the best I can.
Appreciate your time this morning. Thank you so much.
Now next time, don't say you don't want to be in front of me.
No, those were my words. I wanted to be in front of you, but we just wanted
Those
to
were the
do it
words
this way.
that I heard, whether you said them or not. Good luck. Have a great day. Take care.
Have a great weekend. Thank you. Bye
This
for
is
now.
plaintiff mother's motion to enforce a judgment of divorce. However, all you're really asking for is you want the friend of the court to be involved in your child support. There is nothing to enforce as far as your judgment of divorce because you made some kind of agreement outside of the judgment that I can't enforce some kind of your agreement that's outside of the judgment itself. However, you've asked to have the friend of the court apparently involved in your child support. Is that correct?
Yes, for back payment.
Well, you're not gonna get back payment, because that's not the way this works, but you can get, have you contacted the friend of the court to opt back into the friend of the court?
Yes,
All right, and you have opted in?
yes.
All right, sir, what's your statement?
I'm just here to see what's going on.
All right, well, she's opted back in and I'm not sure what the appropriate amount of child support would be. I think it's appropriate that I refer it to the friend of the court for a determination of the child support. The child support will start when you filed this motion, ma'am. And you'll also be, the friend of the court will ask you for all your financial information and you also have to prove the daycares. I understand that's a big thing for you also. You're gonna have to show to the friend of the court that it is there. The friend of the court will review it and suggest an appropriate amount. In the meantime, sir, I'd suggest you help out, but I can't it's not in the order. You guys opted out, and that was not the brightest thing, but oh well. You understand, ma'am?
Yes.
Understand.
All right. It's your child, sir. I would hope you would help out and support. Good luck. We will, I'll send it to the friend of the court so that they can get child support determined at an appropriate amount and get it going as soon as we can. All right. As well as
Sounds good.
Ms. Wolfram on
Thank you.
behalf of the plaintiff. This is a couple of motions filed by father. The first one is an objection to the 9/22/23 order. Sir, I don't know what your objection is to it, because quite frankly, you haven't asked to appeal the order. The order is the order. The order was entered. And you haven't appealed it. You haven't asked for a rehearing. You just kind of want to go over everything that was in the order and try and change it. That's not appropriate. The order is the order. There's nothing to clarify.
There is one thing to clarify. I've tried to contact the counselor and, well, he doesn't call me back. And they also.
That doesn't have anything to do with the order. I made the order. Okay.
Right. So I'm wondering if we could just put in there that I can also get his email address.
The order is the order, and unless you want to object, if you want a rehearing or an appeal, otherwise, this is basically a frivolous appeal that you have got to pay for the attorney fees. It's not, I mean, I'm not going to get into micromanaging everything about this. The order says what it does. And if you don't like it, you can appeal it. And everything. I don't know if you're even within the appellate time anymore. Or you could have requested a rehearing, but this is not an appropriate. I mean, there's nothing to object to. You just want to change the order. And that's not an objection. That's you just want to change the order. And that's not appropriate. And your Miss Wolfram's got to come here and defend something that isn't appropriate to defend.
Well, I apologize. I thought I was doing it the right way. I know I was a bit outside the time, but apparently this is not the way to do it. So I should be requesting a rehearing. Is that right?
I'm not going to give you legal advice. It would have been appropriate to do something different, but this is not it. And as such, I'm going to give some attorney's fees to Ms. Wolfram. Ms. Wolfram, I assume there isn't much you wish to add to this.
No, Your Honor.
Second motion is regarding orthodontics. And I can't stress to you enough, Mr. Cuomo, never are you going to be able to cite Google for your authority. I mean, I have no idea what's behind Google. You cite Google as an authority for something, and there is nothing anybody can question anything. It's not authority to anything. It's ridiculous to cite that. I mean, is it put out there by somebody who knows something about it that Ms. Wolfram could examine or something like that? It's ridiculous. And as far as I don't understand the disagreement on the orthodontics, it appears that we are going to have an evidentiary hearing regarding legal custody because of this precise stuff. Now, as far as whether or not there is orthodontics that are, because there still is joint legal custody. And if you guys can't reach an agreement on that, I've got to have a hearing on it up till any time when there's not joint legal custody. And is this an emergency type of thing? Ms. Wolfram, tell me where you're at with this.
I mean, frankly, we were considering filing our own motion. I wouldn't call it emergent, but it is relatively urgent. So everything that he stated is true to the extent that the child is in need of this care. And the longer we wait, the more problems and the more complications result. So we would like to have it done as soon as possible. But as the court can see, it's not even that Mr. Quano seems to disagree with the treatment or even disagree with Ms. Hodgkinson's chosen orthodontist. He just wants more time. He wants more information. There's never an answer. So I did pose to him a request to either agree or disagree to get a clear answer on whether or not we could proceed with Dr. George so that we could then file our motion to ask this court to grant or deny or add it potentially to the, to the evidentiary hearing docket. But he preempted me by filing this motion. But yeah, that's basically the problem, is that he doesn't disagree. He doesn't give a clear answer as to yes or no. He just tries to drag this out. If I'm not mistaken, they've been exploring this since May. And August,
This particular.
this particular since August. So, you know, and both doctors gave the same opinion. These parties have a decision-making order, and that order states that it was supposed to help the parties make timely decisions for these children. But Mr. Quano refuses to give a clear answer as to yes or no, and that's where we're at in a lot of these. So, I mean, we'd love to have a hearing on whether or not we could proceed with treatment and, you know, under which clinic would it be, obviously, my client's preference is with Dr. George in Holland because it's a shorter drive. And, you know, again, Mr. Quano doesn't appear to disagree that Dr. George would offer appropriate treatment. He just wants more time or, you know, more information, and it will never be enough.
Mr. Quano, do you agree or disagree? Otherwise, if you disagree, I'll set up a hearing as quick as I can, and I'll have the hearing and charge appropriate fees. Yes or no?
Well, Your Honor, I didn't want him to have unnecessary x-rays, and so that's why I was trying to have this hearing with the relief that I asked for. I apologize, there's Google in there, but at a minimum, I want to at least address that.
We don't even know if there will be x-rays. Like, basically, Mr. Quano.
Excuse me.
No, wait a minute, let her answer, and then you'll get your chance.
So basically, the way that the one clinic was playing off the other, saying that we can't, but if we were to go forward with treatment with Dr. George, we can ask him to use, to use the x-rays from the other clinic. The only reason that there's even a question of additional x-rays is because he keeps pursuing this second opinion and there needs to be more. So we don't even know if there needs to be additional x-rays. It's just because of the whole second opinion situation that there is. So if that's the only hang-up, we could answer that question. But, you know, frankly, Your Honor, the orthodontics office has basically told my client that, like, he's harassing them with so many questions. We just don't want to continue if we're not going to become their clients.
Mr. Quano, it's a simple question, yes or no. Can she proceed with that doctor's office or not? If you oppose it, then I'm going to set up a quick evidentiary hearing and make the decision.
Okay, so Dr. George has told me that they will do their own x-rays, and there are, if indeed they can transfer those over, that would be great. So if they can get the x-rays from a line and not x-ray him again, I would agree.
That's fine, then you can proceed with that doctor until, if you need additional x-rays, then I guess you will have to come to a stop and you'll bring it before me. All right? All right?
Should I prepare the order for that, Your Honor?
Mr. Quano, anything else? We are going to proceed with her orthodontist unless they tell her that they need new x-rays, then they will stop and set a hearing with me because I'll make a determination if your child can have x-rays or not.
The only other thing is I was told on July 28th that I'm allowed to drive the kids to their extracurriculars. So can I drive my son to this?
I don't know what you were told. Is it in a court order?
It's in the transcript. That's what.
Is it in a court order? I can't enforce anything other than what's in a court order.
No, I'm not asking you to enforce a court order. I'm just asking if I'm asking right now if we can do that.
Permission from mom. She's shaking her head no.
Your Honor, he keeps, I have no idea what he's talking about. He's quoting me that apparently at some point in argument, I said that it was appropriate for him to drive the children. That's not true. I want to correct that for the record right now. First of all, I have no authority to say that. But to the second point, my client does not believe it is safe for him to transport the children, and he has no parenting time during which any of these appointments will take place. So that is not going to be an option.
Okay. Well, it's in the transcript, so it is true. I can at least say that much. So I wanted to make you aware.
Transcript or not, it might be, but it's not a court order, and I can only enforce court orders.
I did want you to see that they'll come and say things to you in front of your face that aren't true, and then say something else to me afterwards. I at least wanted you to be aware of that.
I'm not reading the transcripts right now because I don't know what it is, and it doesn't make any difference right now. All I'm doing is I'm denying the first objection because it's improper. Ms. Wolfram, what is your hourly rate?
$300.
I'll give you an hour's worth of time for that one.
Thank you, Your Honor.
Right. This one, he has agreed, and you'll draft an order that Mr. Quano, you got 30 days from the time of the order to pay Ms. Wolfram $300. The other one is that the mother will proceed with the orthodontics with the place that she has chosen. If the child has to have an extra x-ray or something, and you don't agree to it, the court will set up a hearing to determine what x-rays have to be taken or not.
Okay, I can prepare those.
It's real simple. Good luck, everybody. Thank you. Present by Zoom as well as the prosecutor, Tracy Brower. And this is to seek a judgment of support. You've given him 130 overnights. Both appear to have employer wages that are quite close to each other. Miss Brower, anything you want to add?
I'm just asking that the court enter the proposed judgment as well as the UCSO. There was a pre-hearing conference on October 19th, 2023. I did use the party's actual income, and I'm asking for the court to enter the judgment as well as the UCSO.
All right, Mrs. Scobby, any thoughts on this? Do you agree, disagree?
So I agreed at first, but after further thought process on it, I don't think the amount that is proposed needs to be that high. I think we can go with a lower amount if able.
I gotta have some kind of deviation for it. It appears, I mean, the numbers are the numbers. They just go in there, okay? Nights and all that kind of stuff, and your income and all that kind of stuff. And Miss Brower is duty bound to follow that, okay? So I don't know what, unless there's some other reason. Mr. Russell, what's your thoughts?
About the payment?
Yes.
Even though we don't have the 50-50 nights, I mean, we've had the conversation about doing it. And if our child needs something, we both make a way to get it for her. So, I mean, she doesn't go without.
I understand, but Miss Brower being involved in this case tells me that there is some state assistance. Is that correct, Miss Brower?
That's correct. What I'm seeing is Medicaid only. Ms. Scobby, is that the only thing you get at this time, Medicaid only?
Correct.
Yeah, because that's the only thing I can find too. Your Honor, because she is getting Medicaid only, that's what I'm seeing. I would be amenable to changing the amount. In fact, in these situations, because she gets Medicaid only, I would be amenable to doing what's called a medical support order only. So that dad would only be ordered to pay $18 per month. And then that $18 a month would go back to the state to reimburse the state for the Medicaid. I'm not sure if the plaintiff wishes me to go that low, or if she just wants, let's say, $200 a month. I don't know. So, but I am willing to reduce the amount because of that reason.
Ma'am, I'll give you your opportunity. How much? What do you want?
We can do just medical.
All right.
I have a question about the medical too.
If I were you, I wouldn't ask many questions because you just went from $300 and some to $18 a month. But go ahead.
So for my job, I can insure her, so she would no longer need the medical.
And you should insure her and get her off Medicaid because they're Medicaid, because the state of Michigan shouldn't pay for your child's medical when you have it available to you.
I've tried to get the documentation for that, and we're in the process of doing that right now.
Get the child on that, and at that point, I would have no problem entering an order that doesn't require it. Mrs. Scobby, you just don't want any support from him other than what the two of you agree to?
Correct.
And you can get her on, we'll take her off. I don't need to have a medical order, nor does Miss Brower, if you can get her on your insurance, okay?
So when I do that, how would I go about informing you guys that I did that?
Contact a friend of the court and tell them that they're on there and see if you can get it done by then. Otherwise, if you have to, the worst that it'd have to be done is you'd have to file a motion with me to change it.
Okay.
All right. I mean, I really do I'd much rather you guys deal with your own child, and I hope that you are agreeing on things. You are. Be wonderful. I'm doing 25 cases today where people do not agree on things. So,
and that's what we want to do, is agree instead of disagree.
And if the child needs assistance or whatever, if you can work it out, put her on your insurance, show proof of insurance. Ms. Brower, do you know if the friend of the court would change it based on that? Probably not. He'd probably have to file a motion, wouldn't he?
Yeah, I'm assuming he's going to have to file a motion, Your Honor.
File a motion in this case, under this case number with your names, saying you wish to have medical support deleted and prove that the child is not on state assistance.
And then that'll wipe away the $18.
Well, it probably will, as long as you come before me and say, and mom says, yes, we don't have any more state assistance. I don't have a problem with it as long as she agrees to it. I'm not going to interfere in your life.
Okay.
All right. Good luck. Thank you. I'll sign that order as soon as you send it to me.
Thank you, Your Honor. Sounds great.
Take care, everyone. Have a good day.
You
Thank
too.
Well, she's not on this one because McCallum's on it now. Okay. So we'll do Rozak and Erber, and then we'll see if we can round up everybody on yours. All right.
I'm good.
Thank you.
I'll go back and watch.
Oh, thank you. You want me to sing any song? I've been singing songs today to people. So.
I can tell that you're stressed.
It's the matter of Rozak versus Erber. We have both parties present, as well as Mr. Cox on behalf of the plaintiff, Mr. Rozak, and Ms. McCallum on behalf of the defendant. This is a motion filed by the plaintiff regarding an order to show cause and to modify parenting time. Mr. Cox, I could start out and say, there was something even right in your judgment that says denial of parenting time, they should go through the friend of the court. Which is the preferred method. So in order to show cause, you should, can you still file with the friend of the court for violations?
Here, I know the client can file a parenting time violation.
You know why he hasn't?
I believe he's filed some.
Yeah, I'm in the process of filing. I've filed and got it kicked back to me, but I think for me, the issue is larger than just the couple denial of parenting times, hence the order.
But if you're asking me to order and hold her in contempt, then it's going to go through the friend of the court. When you say it gets kicked back, why?
There was a deficiency in the filing, basically.
So did you follow up and undefeated?
Yeah, I'm in the process of that now.
Well, then we'll wait for that through the friend of the court to find out what they recommended. And if there's no agreements and stuff, it ultimately ends up in front of me and I determine what bad stuff to do.
Yep.
So, I mean, at this point, the order to show cause seems to be set aside or wait until some later time. Mr. Cox, what would you like to say about the further request?
Yes, Your Honor. Your Honor, this file has a long history of acrimony brought forth by the defendant. Your Honor, she is fixated on vitiating the relationship between not only my client and the child, but also the child and the child's grandfather, unfortunately, and we'll delve into that in a little more detail.
Not much more detail because I'm well aware of what's going on.
All right. But, and Your Honor, I'm not going to walk you down that path, but I do have to address a couple of very important issues of timing so the court can put this into a little better context because, Your Honor, basically what we're talking about is a situation where the child was 4 years old and in 2020 was interviewed by the Kentwood Police Department and the CAC. And the police report clearly demonstrates, Your Honor, I've attached it to several motions to terminate the PPOs that she's filed, is that the child revealed that absolutely nothing was wrong, that she is completely comfortable, not only with her parents, both of her parents, but with all of her grandparents. Basically said that nothing ever happened. And so essentially what the defendant did is she was cited by a police officer for leaving the child in a grocery store. And a week later, all of a sudden, she filed these sexual claims in 2020 against my client. Because the child said that nothing was wrong, nothing ever happened, and that case went away. She then tried to revive the same issue, again, saying that the child was somehow sexually molested by her own grandfather when she was 2 years old. Same issue 2 years later, and now says, oh, well, let's rehash this again. 1 week after she had dumped the child off at my client's home saying, you're going to live with your dad forever, or at least until you're 18.
Let me stop you for 1 minute, though. I mean, all of this stuff is in the past. The prosecutor has denied. The prosecutor wrote a charge. It didn't even get to a preliminary examination. Mother now says a year has gone by. The prosecutor has said, we'll write it if and when there's proof that dad somehow influenced it. It's been a year. I practiced criminal law for 35 years. It's going nowhere.
I appreciate you saying that, Your Honor. And the problem is that the mother thinks it's going everywhere.
Because I understand that, and it's not. Unless there is, I cannot. But I also understand that the mother might have just recently obtained a PPO against the grandfather. And if that's the case, I cannot do anything with that.
Understood, Your Honor. I'm here, seeking my client's relief. But my point is that, yes, the mother still perpetuates this, still coaches the child to do this. And just because she filed another, trying to say it nicely, another frivolous PPO, she filed the same PPO on not the same facts against my client last year, saying that he had broken. I should have said, Your Honor, she filed she likes to file PPOs in Charlevoix County, which is always fun to travel up there. It's a pretty place. But last year I had to ward off a PPO she filed against my client, saying that he had somehow broken into all of her computers and her social media. And the judge just looked at her like, are you kidding me? And dismissed that PPO. So she's a big fan of PPOs. And yes, you're correct.
Fighting this current PPO?
That's been dismissed.
That's been dismissed, the current PPO?
No, the current.
That's the previous one.
Yeah, the PPO against my client was dismissed last year, Your Honor. I did have to take it to a full hearing, but after the full hearing, the judge in Charlevoix.
All I'm asking is, I can't give him time with the child around his grandfather or around his father if there's a pending PPO, and you know that.
I know that, Your Honor, absolutely. And just so the court's aware, and maybe it's not a big deal, but we do have a very vigorously filed motion to terminate that PPO that will not be heard until November 17th. So I'm not asking the court today, Your Honor, to order that the child can be around my client's child. And I understand that. We're on the same page there. The point is, Your Honor, it's this bigger global picture of not only, these wild sexual allegations against a 79-year-old man with no criminal history. More importantly, Your Honor, the behaviors are getting more and more bizarre. Certainly they're couched with violations of parenting time, but more concerning
let me ask you, what is it you want as your relief?
Your Honor, I'm asking the court to determine that there is clearly proper cause here to have a hearing to change custody and parenting time. I mean, there are some serious issues going on here, horrible attendance issues at the school, and we had to file 2 ex parte motions to get the child back into the school. I mean, this is the child is suffering because of this. And this woman, I'm telling you, Judge, I mean, Your Honor, this child is
all right. I understand what you're saying. I do have a lot of cases today. I'm sorry, I can't give you, time to go off on this, but I got to get Miss McCallum.
Thank you, Your Honor. I do rely on our response. I think it details out, our response to all of the allegations that are being made. Specifically, the criminal allegations against the paternal grandfather were not baseless. In fact, the prosecutor even issued charges against the grandfather until it was determined that there was
no probable cause found. You didn't do a preliminary exam or anything. And the prosecutor dismissed it, and it's been a year. And are you telling me that they're still investigating it? How long are they going to investigate it? For 4 years? I know what this is. I practiced 35 years of criminal law, and that case isn't coming back.
So I do not pretend to know what the prosecutor or anyone is doing with the criminal case.
You have a statement from the prosecutor saying we're going to charge this guy in a minute, because it's only in a year ago that said if we find that, dad is coaching or something, we'll bring it back. That's a year ago, and there's nothing even investigated. I'm not going to use that to go on indefinitely, because that'd go on for 10 years. The prosecutor's office doesn't do something, doesn't dismiss it and say, well, look into whether or not the guy's coaching or something. I doubt they have done anything in looking into it, and it's been over a year.
I understand.
Oh, sorry, don't you talk.
I understand your position on that. However, it does not change the fact the reason that it was dismissed was specifically plaintiffs meddling with the child, attempts to influence, manipulate. That is the reason that it was dismissed.
There is a
they'll look into it. It's been a year. How long is this going to go on before it ends?
So again,
you have anything from the prosecutor's office saying a prosecutor's with it and we've almost got it done, or this or that? Do you have anything in the last year to show that this is going to be reinstated?
Their concern is my daughter's health. They do not want to put her through this right now.
Ma'am, they dismissed it.
They dismissed it.
We'll have the hearing then, and you can try and do some of that there, because it just isn't going to happen from the prosecutor's office. The prosecutor's saying they're concerned with their health and stuff like this. No, now before it was because he was potentially coaching. It's been a year. You're going to use this for the next 10 years because they're not going to charge.
I'm not trying.
Your Honor, respectfully, we are not trying to use this at all. We are simply defending against a motion that was brought against my client with allegations saying that there was no basis for the criminal charges, which there were in the past, regardless of if the criminal case is stalled. We're not saying it's going to move forward in the future. We're not saying anything about the criminal case. We're simply trying to state the facts and what has happened in the past. And the fact is that this has all happened in the past, and there is no change in circumstance in recent time to warrant any further review of parenting time in custody. And in fact, it is plaintiff who is trying to draw on things that have happened in the distant past to try and say that now there's proper cause and change in circumstance. Why wasn't this motion filed when all of this was going on? If these were the concerns, it seems to be the fact that they are just trying to use things that happened even previous to when the judgment of divorce was entered to try and renegotiate and get a second bite at the apple with parenting time in custody, which should not be the case.
All right, Mr. Cox, specifically state what the change of custody, change of circumstances since the order of 7/5/22. That's the last order that I have.
Certainly, Your Honor. School year last year, we've attached the attendance record, Your Honor. Horrid, multiple absences, multiple tardies, all playing this litigation game. We had to file an ex parte motion to get the child back into school last year, and Judge Hillary signed that order. This is in 2023. Now, in the fall of 2023, we have the child again with multiple absences. I got to file another ex parte motion to get the child back into school because she's AWOL for a week. This woman has lost her mind, Your Honor. It's not just the picture of the absences. It's the whole picture. And now we're dealing with multiple PPOs on her fixation that she's somehow going to take custody from my client because her 79-year-old.
All I'm asking you is for the change of circumstances or proper cause being the school record of the child.
Yes.
Since then, proper cause being the change of circumstance being the for attendance. What are the other things? Just don't go off on this stuff. Just tell me your facts of what you think.
I think there are multiple examples in the last 4 days, the last 6 months. The mother of this child, Your Honor, is not only withholding the child from my client, she is threatening. She's living in a world now where she thinks she's going to move to South Carolina.
Missing parenting time now?
I'm sorry?
Is your client missing parenting
He
time?
continues to miss parenting. Not right now. Things are back on track now that the motions have been filed. And I do want to correct myself, Your Honor. Our office did file those parenting time complaints with my client, and I apologize to my client. That was not he who directly filed those. So apparently where the technicality was, we screwed up and not him. I just wanted to point that out. But Your Honor, yeah, I mean, certainly I can't hide from history. This has been the continued history. And I'm going to be honest, Your Honor, my client and I thought about bringing this motion last year when she bought all the crazy stuff up in this PPO and continued the alleged criminal case against her father. I didn't think it was enough. But when you got to destroying the child's education for the last year, I think we're at proper cause, Your Honor.
All right. In your brief response, because I'm inclined to say that there is enough, at least for proper cause or change of circumstance, because of the schooling that provides part of proper cause. It does affect one of the factors. I'm not saying I'm not changing anything here today. Nothing. But there has been allegations of significant him being unable to exercise his parenting time. The most that he will get today is what I believe to be an evidentiary hearing regarding change of custody. It's going to be a mess, I'm sure, but that's what I'm looking at right now.
Your Honor, just to respond quickly to the school allegations regarding the attendance, my client has attached to our response that the child had COVID, that the child has had illnesses, been excused from school when these absences did take place. Additionally, this motion could have been filed if it was in relation to school attendance anytime in the past year, and it wasn't. Clearly, that was not the driving motivating factor behind plaintiff filing his motion at this point, because if he was so concerned about the school, why was this not addressed within any time?
Apparently the judge got involved with an ex parte is what I'm understanding. That sounds like it's addressed.
So there was one ex parte 2 years ago that was granted, and it was unnecessary because the child was already back in school by the time the motion was even filed. Additionally, the second ex parte motion was denied.
You know, that's absolutely incorrect. The first ex parte motion was granted last year. First of all, that's number one. Number two, she is actually correctly citing the facts. The second ex parte motion, because she was AWOL from school for a week, was denied by Judge Hillary only because he said, Sean, I already gave you an order making her get back in school. So file something different, but I'm not going to give you an ex parte order when you already have one that says the child has to remain in Grand Rapids Christian schools.
All right. I'm just going to, I believe that there is sufficient Vadvarka to schedule an evidentiary hearing. At that evidentiary hearing, that Vadvarka will be in the air. Will have to be shown, as well as any other factors that are necessary, including established custodial environment. Both attorneys know what I'm talking about. You have to do all of that stuff. I'm not saying I'm changing anything. I'm gonna have to hear the evidence. And in the meantime, everybody is going to follow the court order that's out there. I don't know what it is, but the parenting time and everything is going to be followed, or it's not going to go good for the person who is withholding it. I'm just telling you right now. You're going to have a really fabulous reason that's going to be provable.
I would like to respond to that as well. My client has not withheld parenting time. The two instances
We'll find out about it in here. He's filed parenting time complaints. I'm not finding on anything. I'm just finding enough to have a hearing because it's clear I got to have a hearing. These people are beyond repair right now. And so as a result, I don't know whether any change in custody should occur or not. I have no clue at this point. All I know is that parenting time and everything in that custody order will continue, and that Mr. Rosick will not have the child around his father while there is a PPO on it. If you wish to file something further to say, even after the PPO is gone, that he shouldn't have the child around the father, that'll be up to you, Ms. McCallum. But right now, there is nothing that he can allow the child around his father while there's a PPO. Once that's off, then it'll be up to me to maybe make a hearing on it. A ruling on it somewhere down the road. I got a lot of motions this morning. That's the order of the court. We'll get to both counsel for an evidentiary hearing whenever it works for both of you. It's a ways out, I'm telling you right now. We aren't scheduling hearings for quite a while.
Right.
Anything else?
Thank you, Your Honor.
No, nothing further. Thank you, Your Honor.
Good luck, everyone. Thank you.
Thank you, Your Honor.
Okay, I'll call your next case.
John?
You stuck with me for 2 cases? What? This is a horrible Friday for Greg.
Oh, it's a great Friday for the YouTubers who you become a favorite with. But as far as me, holy smokes. What's the next case? Oh, yes, you got that one that you're entering a default versus Field.
Yes, Your Honor.
Both parties are present via Zoom, as well as Mr. Cox, who is representing the plaintiff. This is an attempt to enter a default custody judgment. We were here before, and I think you were, Ms. Field was this the one that I remember that was actually at your office and you didn't realize it? And so we came back to figure out what was going to happen?
That sounds like something I would do.
Ms. Field, have you had a chance to review the proposed judgment?
I did. I actually sent responses in as well to those.
Well, you understand that you're defaulted.
I understand. I don't really understand.
You didn't
I do know. I'm sorry.
You didn't answer the complaint and stuff, or no, I believe, wasn't it Judge Hillary who defaulted?
Yes, Your Honor, that's
You
correct.
didn't show up at a settlement conference, and Judge Hillary entered an order that defaulted you, which gave Mr. Cox the right to send in basically whatever he wanted.
Okay. Can I explain? Like the August 9th hearing, I had no idea about. I don't have paperwork on it.
Ma'am, you have to file that. You have to file something to set aside the default. Okay, I can't do it or anything. If you did not show up at that, you needed to send in a motion to Judge Hillary to say, set aside the default.
Okay. Is that still possible for me to do, or is it too late?
What have you talked to Mr. Cox about what you think is wrong with this custody?
Well, I haven't talked to him. I do know this is what is so confusing for me. It's August 9th. I missed that hearing because I did not know about it. But Judge Hillary still signed the order August 31st. So that's what is kind of confusing for me.
Signed the August 31st order, what, defaulting you?
No, it was the FOC, from FOC, the recommendations from FOC. He signed the order for that on August 31st.
Oh.
And that's what we're currently following.
Okay.
So
because you didn't object to that either.
I did not, because I'm okay with it.
Well, then if we're following the FOC recommendations and Mr. Cox has put them basically into this judgment, then why are we here other than to sign this judgment?
Because it's completely different from what the judge signed, the order the judge signed.
Mr. Cox, yeah, help me.
Your Honor, the sequence is incorrect. Yes, the friend of the court order ultimately was entered, but ultimately she did not show for the settlement conference. A default was entered. There was I think we had some improper service issues last time, and that's why this was adjourned. But Your Honor, yes, I prepared a default judgment of custody. It is equal parenting time. It does have some specifics that my client was looking for, but she's been defaulted, and we're asking the court to enter the default judgment.
And your objection to this specifically, ma'am, because even if I were to have a hearing on it, you're not going to be able to present much in the way of evidence because you don't have the default set aside. And that's just the way these things work.
And that's what I'm not clear on. I didn't know that at all.
But you see, what am I supposed to do? You're not following the law. And so you're asking me to just say, okay, give me a chance to do anything that I want, even though you've been defaulted since August and we're in November.
Well, this is why this is so confusing. I don't have an attorney. I don't know how this I don't know how this works.
Why haven't you gotten
So what I'm trying to understand is, okay, I missed the August 9th hearing, but the Judge Hellery still signed this FOC order on August 31st. So this is what we've been following. So after the order came out, I got the default from Franklin's attorney. So at this point, I don't know what to do.
Mr. Cox, was there something that was signed from the friend of the court or whatever?
Judge, Your Honor, the friend of the court recommendation was issued, and it's true that neither party objected to it. But again, after that happened, we went to a settlement conference, hopefully to maybe hash some issues out. She did not appear, so the default was entered, and we've entered a default judgment.
The settlement conference was
the settlement conference was from August 9.
Yes.
And then you entered an order of custody, parenting time, child support pursuant to the friend of the court on August 31st.
Correct, Your Honor, an order, not the judgment. I'm trying to get the judgment entered today because she had been defaulted.
I understand, but wouldn't it be appropriate to incorporate the order that was already signed in there? That's all I'm saying.
Your Honor, there are just some tweaks to the issues, Your Honor, but I told my client because he's been defaulted, he can present, or she's been defaulted, that we can present a judgment. I don't believe, Your Honor, that my hands are tied to any friend of the court order, as long as I prepare a default judgment that is fair and reasonable, and I believe that it is.
And both orders basically provide 50-50?
Yes.
No. I know in the other one, he's asking for physical custody.
Huh?
And in the order the judge signed, we have 50-50.
I don't think I'm tied to the other order. I don't know why we keep saying
I'm not necessarily saying you are, because that was but it does make it more difficult because there was an order entered. But what are the major changes to this? The custody appears to be primary to your client now. Is that correct, Mr. Cox?
Physical to my client, yes, Your Honor, that's true.
And no matter what, I got to determine that that's appropriate.
Mm-hmm.
I mean, I'm not saying it's not, but is there a reason that the friend of the court recommended and you did not object to the fact that it was joint physical and joint legal?
Your Honor, at the end of the day, I try to tell my clients that the term joint physical has as much importance as this paperclip, but it's something my client...
I'm not disagreeing with you. Joint legal means something, but joint physical doesn't. But then if that's one thing she's objecting to, why don't you just put in joint physical?
I would have to defer to my client on that. Mr. Hunter, could you chime in?
It's hard when you're on mute, sir.
Franklin, you got to unmute yourself.
Okay, thank you. I believe the joint physical might be because I'm also a legal citizen of Jamaica, and eventually it would not bar me from traveling with my child if that's the case. That's about the only issue. And seeing that I am not sure of Stacia's permanence or where she's living, I wanted to make sure I secure.
I've been living in the same place for almost a year.
Stop him, stop.
You know that.
Stop. We've been listening to you and not him.
Okay.
Your Honor, I think I can resolve this issue fairly quickly. Franklin, physical custody really doesn't have much weight at all. I think, and I think what you're concerned about is more a joint legal custody issue, and you are correct. In order for you to travel to another country, your spouse or the mother of the child, even though you have joint legal custody, has to agree to cooperate with you on passports and getting to be able to travel internationally. So she would have to agree to that, Franklin, or I would have to bring a motion in front of Your Honor, to make sure that you're allowed to travel to Jamaica, but it has nothing to do with physical custody. So my recommendation would be to get this resolved. Frankly, we just agree to put joint physical custody in there. Does that make sense?
That's fine.
Okay.
But I again, I will always be concerned because I'm, like I said, I don't know how her living condition is, but
well, but
I know I'm providing.
That's something that nobody knows what's going to happen in the future. Nobody.
Sure.
Okay. I mean, who knows? You might decide you want to go back to Jamaica and all that.
No, I have secured permanence for him.
I understand, but it's a long life. Okay. And a lot of things change. What other issue do you have with this, ma'am?
The parent time schedule that he wants to do. He says no child support. Also, he knows that my daughter's father is a felon. He put no felons in there.
Your daughter's father is a felon.
He's a felon, yes. And he says here, neither party shall allow a minor child to be in a company of felon, whether the parent is present with him or not. And I don't know if you received my responses. I couldn't really speak on this. My daughter wrote a letter regarding that.
How old's your daughter? And your
daughter's 14 years old.
Well, I'm not going to read your daughter's letter.
Okay. The right of first refusal. I'm not really clear on what that really means, but
I mean, the party's going to go away for a while. They got to give the other party the child.
Which I'm not okay with any of those. And also the parent time schedule is completely different from what the FOC recommendations were. It was our old schedule that just does not work anymore. Like I literally don't get any time with my son consecutively with that old schedule. So I'm hoping.
Here's my biggest problem is unless I find that there's something really wrong with the custody provision is going to be changed to allow for joint physical. All right. And because you've not moved, and I don't find anything inherently wrong, you're getting basically 50% of the time. He's getting 50% of the time. It was, that's what you guys went through the friend of the court with.
Mm-hmm.
I don't think that other than, I would ask Mr. Cox to modify just the term of the joint physical for the appearance of it. I don't see anything that is inherently wrong with the judgment, and you have not done anything. The judge said you can file a judgment, and there is nothing that's in here that seems to be anti your child or anti you. I am going to sign the judgment.
You're going to sign his default judgment? I'm just trying to be clear.
I'm going to sign the default judgment once he has modified the physical part. All right. Okay, Mr. Cox, you understand what I'm saying?
I do, Yarn. We'll email that over to you today. No problem.
Yeah. And ma'am, you can make motions or do whatever you want, but
I will.
When you are, I feel bad, but when you are defaulted, you lose certain things. All right. And you have to, and saying that I don't know what I'm doing, goodness gracious, it's your child. I can't imagine you didn't go to an attorney to say, help me.
Your Honor, first, I don't have money for an attorney.
I understand, but it's probably one of the most important things in your life. And I don't know what else to say on this. I'm sure you'll be back on, you can make motion, parenting time, custody, child support, whatever is always up in the air. Is there a reason that there is no child support, Mr.?
The parties do have equal. It's calculated at 182.5 overnights for each party. And we in the UCSO it says 182.5 overnights each party, and we did use the incomes, and we believe that is what's appropriate under the circumstance.
And so he would be paying her $132 a month.
That is correct, Your Honor. Yes.
All right. That appears to be correct. So there is no child support, ma'am. It's maybe not as much as you want, but the numbers are in there. You can proceed in any way you want, but the court finds that there is nothing that is inherently wrong. I believe it's in the best interest of the child, that which has been presented. And I will sign the judgment once you send me, if it's just the first page or something that has to do it or whatever.
Certainly, Your Honor. We'll do that right away.
All right. Good luck, everyone. Thank you.
Thank you, Your Honor. Have a good weekend.
Thank you.
Both
Thank
parties are present via Zoom. They also have their attorneys who are present. Ms. Litchford is just connected as of now, but Ms. Rademacher and Mr. Scazzari are present, as well as guardian ad litem Stacy Van Dyken. This is a motion to enter, basically to enter an order. I think, do we already have it set for some legal custody down the road?
We do.
So that's just out there. You've also asked for psychiatric referral and breathing treatments. You sent me an order about this.
Correct.
It seemed to make much headway.
Apparently not. I did send the order to the guardian ad litem and Mr. Scazzari for approval. And his objection is not even responsive, frankly, to the motion to submit. He's got it confused, I believe, the difference between a psychiatrist and a psychologist. The court already granted the psychiatric referral. So that's what the order clearly says. And then the court also indicated that the guardian ad litem would provide a recommendation, which she did, which is that.
Mr. Scazzari also provided a recommendation of the same person.
He did. And then apparently he decided against that.
Then hold on.
Yeah.
Ms. Van Dyken, you don't have a problem with that, Dr. Atry?
No, Your Honor, I have used her in the past, and the pediatric psychiatry realm is not that large, but she's very well known and does a great job. So that's why I recommended her.
And Mr. Scazzari, at one point you proposed that as one, and then sometime later decided, no, wait a minute.
Your Honor, I was mistaken. After having talked with my client, I think my client's concerns were that the children weren't being evaluated for trauma, anxiety, and that sort of thing. And Dr. Atry is not a person who specializes in that. So that was my concern, or rather my client's concern. And I was mistaken in suggesting that doctor in the first place, Your Honor.
No, but I mean, it's kind of like, here you go, everything now, after everybody's on board, then you go, oh no, wait a minute, something else. I'm going to enter the order for Dr. Atry. I think it's appropriate. I think the guardian agrees with it. You proposed it to begin with, along with your client. Because you say right in here, he would suggest Dr. Atry, an expert in developmental behavioral psychiatric, or Dr. Brett May. Your client proposed it. This would go on forever. If then next thing you know, you want Dr. May, and they say, okay, we'll go to May, and then you go, okay, no, wait a minute. Dr. Atry is appropriate, and I'll sign that order.
And
Next
just for the record too, it's a psychiatric. We need a psychiatrist, not a psychologist. And their requests deal with psychology, which that's not even where we're at. So just for the record, Atry is the only psychiatrist, and that's why it's appropriate as well.
Dr. Atry will perform the evaluation. Thank you.
Your Honor.
Okay.
What?
The only thing I would say is if we could add to Ms. Rademacher's order, is that the children be seen for trauma and anxiety, that they be that referral reflect that. My client thinks that that's important, especially given the fact that these two parties are so high conflict. I don't think that's an unreasonable ask on his behalf.
The children are being sent there for a psychiatric evaluation, right?
Correct.
That seems to be sufficient. They're going there for a psychiatric evaluation. If there's trauma, they'll look into it. If there's whatever, I'm not going to specifically state. You'll get a copy of the report, and if it's deficient, you'll get a chance to complain about it to me. That's Ms. Van Dyken. Is there anything wrong with that, or do you want additional language? Or what?
I don't need additional language. The children have been processing trauma and anxiety with brains and their other counseling. So this psychiatric referral was a referral from the psychologist. So we're all encompassing.
Yes. All right. Next issue is about the breathing treatments. The last time we were here, it was my understanding, I thought I had a breathing treatment protocol right in the motion. Okay. Didn't I?
Yes.
And that was the one that was going to be entered. Is that correct?
Correct.
Is that the protocol that was sent with the order to Mr. Scazzari? Or was there changes to it?
So from the time that he said, I'll sign the order, to the time that I discovered he wasn't going to sign the order, the parties had another appointment with the pulmonologist. So the order that you have that I attached to our renotice is the, or motion, excuse me,
Is it modified
is
one?
it is the most up-to-date breathing treatment protocol that has been issued by the doctor.
Here is the problem. When I issue an order that is the protocol that will be entered, that's the protocol that will be entered. If you want to change it, you almost have to come back because the order was the order at the time. And I get this several times a year where somebody says, yeah, but now something has changed, so we just decided to change it. That's the order that I ordered said that was the protocol. Okay. Now, if you really want to change it and there's no agreement or something like that, I suggest, Ms. Van Dyken, I suggest you're going to get a lot of money from this case because these individuals can't agree on tomorrow.
I sat in on the pulmonology appointment, Your Honor.
Okay.
And the new updated one took into account both parties' concerns about timing, oral steroids, inhalers, etc. So if the court needs a new motion to do the most updated breathing treatment protocol, then that should be done. But that's what I would rely upon from this last.
You know why I'm saying that? Is
I do.
The last order was the last order, and now
Understood.
you're going to try and change it. Now, Mr. Scazzari, it's almost guaranteed that if they come in and say this is the updated one from the pulmonologist, I'm not sure why I wouldn't agree to it because I am not a pulmonologist.
Right, and Your Honor, we're not objecting to the actual asthma home management pediatric plan of care. What we're objecting to is the language that Mr. Rademacher suggested, and what we're saying is because this order changed in the interim between the last hearing and this hearing, Your Honor, we're just asking that the language on the order state simply that the parties follow the asthma home management pediatric plan of care, because Dr. Kuhn himself has said that this plan is flexible, it's not absolute. We're trying to avoid, for the benefit of the kids, we're trying to avoid, attorneys making, medical decisions for these children. That's all we're trying to do.
I can't see that anybody's working in anybody's best interest, quite honestly. Ms. Van Dyken, have you looked at the order that is proposed by Mr. Rademacher?
I have.
And do you believe that's the best, or some of Mr. Scazzari's language? Should that be in it, or what? I'm not a pulmonologist, and I'm going to have that.
Nor am I. But and this is why people need to follow doctor's direction. That is the recommendation from the pulmonologist. The parties follow that updated protocol. There's really no wiggle room in that. So it's very specific. What zones, when, how long, how many days. That needs to be followed.
And that has been given to Mr. Costello.
I'm sorry?
That protocol has been sent to Mr. Costello through Mr. Scazzari.
I believe it has. I received a copy of it as well.
Did you receive a copy of it?
Your Honor, I'm looking right at it. Mr. Costello has had it. Again, this, like I said, we don't want to essentially put language in the order that backs us into a corner. I mean, this plan is supposed to be flexible. It's not absolute. And obviously it changes. So what my suggestion was to make it better for everybody is that, the language of the order state that the parties are to follow doctors' recommendations and orders on this pediatric plan of care.
Does it say on there that it's all flexible?
No, the order that I provided to the court details out the plan, and then the plan is attached. You can look on it, and there is no word that says flexible. It does say in the yellow zone. Let me see here. I think that if the rescue medication is needed 4 to 6 hours for more than 24 hours, call the PCP or PEDS pulmonology. That's the call that the defendant likes in regard to, whatever flexibility he may be looking for. So it's all contained within it. What we've done is we've set forth everything in that plan in the court order so that it is part of the court order and needs to be followed, because the problem is that parents are, and specifically the defendant is interpreting what the plan is, and we need to make sure that everyone follows the plan. And as Ms. Van Dyken said, she attended the appointment as well. The parties have had the order, and I don't believe she objects to it. So I would ask the court to enter.
It's connected to the order, and the plan says what it says. I don't care what it says. If it says you have to call a PCP within 12 hours or 48 hours or whatever, then the parties are gonna be stuck with that plan. All right, and if there is wiggle room for it in there, then there's wiggle room in there. I don't know, I doubt that it says, 14 minutes after the kid does this, you gotta do that. I'm sure there is some, but we'll deal with it at that point. It appears that that is appropriate, as long as the plan is attached to the order. All right?
And it is.
I will sign that order.
Your Honor, what if this plan changes again?
What about it? You want to come back in front of me? I'll keep hearing you, and I'm gonna start charging some attorney's fees. But I don't, if these parents are so miserable that they cannot even take care of the children through the pulmonologist and stuff like this, and they can't work on it, then I'll just keep having hearings on it, and you'll just keep spending money with a guardian ad litem and keep going on with it indefinitely. What do you mean? What if it changes? What do you want me to answer?
Your Honor, we're trying to keep the language here simple, Your Honor, until our January
But
29th.
it is the plan now. Am I supposed to say if the plan changes, then everything will change? Because I don't know. The plan is what it is now. If it changes and nobody can reach an agreement on it, then you're foolish and you'll be back in front of me. That's all there is to it. I'll sign the order as long as it goes through Miss Van Dyken to know that the plan is attached in its entirety. All right. Good
Your
luck.
Honor, there are 2 orders then for you to sign. And I did request attorney fees because of the need to file this motion. I would have submitted it under the 7-day rule, which is why I asked for approval prior to the expiration of the 7 days. And that costs my client additional funds to file a motion, and I would ask the court to grant attorney fees as a result of that.
I'm not gonna grant attorney's fees now, but boy, I'm starting to look at them as we keep coming back.
All right.
This is beyond. I'm not gonna grant attorney's fees because I'm gonna have attorney's fees go to Miss Van Dyken, who is gonna be doing this. And Miss Van Dyken, it looks like you're gonna be raising this child. Congratulations. We're adjourned.
Thank you.
Thank you.
We have Jenny here now.
All right. Jenny Bryant, is there an Egg McMuffin over there somewhere?
Well, I had it. Sorry, I gotta throw it in the trash.
Why you throw it in the trash?
Well, I ate part of it because I took my insulin
Oh.
and I need to eat like ASAP. I didn't know it was coming up yet. I'm gonna go throw it away.
No, you don't have to throw it away. I love Egg McMuffins. It's the only thing I like. No, that's all right. Because he doesn't hear anything I'm saying. See, it's always good to have Mr. Gordon here because I usually say something sarcastic, but I can't even think anything to say to you today.
Well,
I
wait a minute,
can't even
and
pick
figure
on
it out.
you
There'll
today.
be something.
I can say stuff about Miss Bryan, but I can't figure out something to say about you. It's a long morning here. We're here on Schoonover. Both parties are present with their respective attorneys. Mr. Gordon for the plaintiff, Mr. Schoonover, and Miss Bryan for the defendant. First thing seems to be settled. Mom and the defendant had filed for passport for the child. It appears that everybody agrees to get the child, who is like 3.5 years old, a passport. Can the parties agree that they will cooperate and get that thing going within 2 weeks?
Well, the only issue, Your Honor, is what I put in there is my client's willing to do that as long as there's
I'm
an
not
agreement.
going there yet. I'm just going for the passport right now.
He's okay with, she was just in Canada three months ago, so she didn't need a passport, and she was up there for at the pole dancing place that he knows that's where she's going, and that's why we pointed it out. It's just not appropriate for the daughter, and he's asking for some compromise.
Parties can agree to get a passport. As far as travel and this kind of stuff, that's the next issue. Miss Bryan, I don't know when she's planning on going. I don't know what she's planning on going for, but whatever it is that she's planning on going for stuff, she will provide information to Mr. Schoonover, which she should, as far as what she's going for. Okay. Now, Mr. Gordon, I've looked at some of the pole dancing things, and it's not exactly full of what I would consider exotic dancers. It looks like some women who just like to work out doing that. I know there are things and I don't know whether or not I'll approve it or whatever, but if you don't want her to go for some reason, you can come back in front of me at some point. But Miss, well, I don't think it's Schoonover anymore, but that's the name I know you by. You will provide well in advance what the plan is for going to Canada or wherever you're going to go. go. Just like Mr. Schoonover will provide stuff if he takes the child somewhere, and certainly, but let's get a passport for the child. All right.
Yeah, I mean, somehow she was in Canada 3 months ago without a passport.
I don't.
So we didn't fully understand why it was so urgent suddenly, because she was up there, she was at her friend's place, who also has another fitness place like her. And the reason that I actually put it into my response was I'm pointing out that these locations are not appropriate for little children. That's my client's concern. He's not wrong for having that concern. I think he's legit.
I'm not saying that he's necessarily wrong, but if she has a friend up there and she goes and visits and they do this, it's also a fitness thing. And I don't know that I'm not going to say that she can't go there. I don't know that she takes the child into a exotic dancing place and does stuff, or whether or not it's simply a fitness matter.
Well, it's masqueraded as a fitness thing, Your Honor. But she is a former dancer. We're not knocking that, but she teaches other dancers, other strippers. That's what this fitness
all
thing
it is, though. I mean, I clearly get from the stuff you sent in that it is not just that. It is. I'm telling you, I looked at the pictures to see if it looked like there was a whole bunch of exotic dancers there, and some of the pictures look like they're just normal people doing exercise with it. They find it fun, any different than if they went to a whatever in the heck.
What I pointed out, Your Honor, what I pointed out was her own fitness, whether you want to call it a fitness or a pole dancing studio.
But that doesn't mean that if she goes there, that doesn't mean if she goes there that she's taking her there to the studio or whatever.
I know. All we wanted was some compromise for her to say, fine, I won't do that. And she doesn't want to say that.
All I'm telling you is she will provide information of where she's going, what the plan is through Miss Bryan. She will get it to you, and then you guys can figure it out from there. I'm not going to say anything about it, yes or no, right there. I want the passport that you guys agree to, and then from there on, that'll be something out there. I don't even know when she plans to go there.
I agree. I understand.
Quite frankly, she apparently went before, and the child seems to have survived it. So without it,
well, it's not a matter of survival.
Passport, and they will provide information.
It's not a matter of. It's not a matter of survival. It's just what's appropriate, Your Honor.
Is that okay? Ms. Bryan, you'll provide information about where she's going and stuff.
Well, yeah, I have two comments, Your Honor. Number one, I'll prepare an order that says that the parties will cooperate with the passport within 14 days. Number two, I'll prepare in the order that she will provide information as to where she's going and the plan. I would like that to be mutual in the event that either party travels out of the country. Is that acceptable?
Yes.
All right. And then the final comment is that with regard to this issue on pole dancing, this is a business. It is an exercise business. And my client was involved in it before the parties married and all throughout the marriage. So for him to suddenly say he thinks it's inappropriate is quite disingenuous. That's all I have to say. Thank you.
I will make the decision if he objects because of something she intends to do somewhere, it'll come to me and I'll make the decision. All right. That's the way these kind of joint legal decisions go. Both parties will be responsible to inform if they're going out of the country or something, where they're going and what they're doing.
Thank you.
Sure.
The last part is the dance recital in May. I know Mr. Gordon says this is way in advance. However, I do understand that if she waits too long, then something else will come up and then, no, we can't do it. I already got other plans. There's nothing wrong with asking for it for the time. And I don't think there's any reason to have a problem with saying that the child can attend the dance recital on his weekend. Mother can obviously go to the dance recital. I assume that mother would look at. I took my kid to hockey when he was young. All right, and I went to the locker room. His mom didn't go in there and put his skates on and stuff like that. It was all the men going in there. I assume that the mother would be in there doing up her hair or whatever. I mean, I didn't do my son's hair for hockey, I can tell you that, but doing other stuff for it. That's just, is there any problem with her, whether it is either exchange the weekend or make sure that everybody goes to this recital? What's wrong with that, Ms. Bryan?
So, and that's what
you're asking me
about, Your Honor.
That's what I'm asking you. Even though Mr. Gordon's talking, I'm asking you.
Oh.
Just not listening to anything he's saying. Go ahead.
So if the question's for me, I mean, we would love to we would prefer to trade weekends, but if not, as long as she can do the preparations, maybe have the child an hour before, or he can deliver the child to the location an hour before so she can do the hair and the makeup and whatever they do for that. That would be wonderful. That's all we're asking.
That is absolutely beyond reasonable. All right. If he would rather trade his weekend, that's fine too. And I'll give him that opportunity. And for you, Mr. Gordon, if you wish to talk to your client about whether you'd rather trade the weekend and do that, that's fine. You can have till Monday to inform Miss Bryan whether you'd rather trade the weekend or whether or not he makes sure that he gets there early enough so she can do the stuff for the girl and everything. That's just the way life goes with a 3.5 or 4-year-old girl.
I understand. May I at least make an argument, Your Honor? That's what Mr. Schuler was paying me to do, to present what his take is on this. And what his take is on it is he's tried to negotiate with her. He's tried to get the details. What he told her, if everybody reads what his response was that he would take her if he's available. He has family in Georgia and Tennessee that he goes on vacations with, and he plans. He can't control, just like a recital, he can't control when the family event is going to take place. And so basically, she wants an answer from a year down the road, and if he doesn't respond, that she's going to file a motion. And so this is opening the door even further to where whenever she doesn't get what she wants, whether it's on her parenting time or his parenting time, she can waltz into court, hire Miss Bryant, and basically she gets his parenting time and her parenting time. And so my argument, and I understand, Your Honor, you're in control, you're going to issue your order, but these are rules and laws and thresholds that need to be modified if you're going to amend parenting time. These folks negotiated this schedule, and he doesn't get any flexibility from her. The difference is he doesn't hire me to file a motion to allow for his daughter to go to gymnastics. He has gymnastics on his time, and when she has the dance that falls on his time, he takes her there. But he doesn't want an order or a commitment of what he's going to do if the family vacation. So what are we going to do to be fair to my client? That if there's a family vacation, she needs to schedule events on her time, just like he schedules events
she can't
on his
schedule the
time.
recital on her time.
Well, we don't even know if she's going to be in the recital.
That's right. And if she's not in it, then it's all moot. She's asking far enough in advance to be able to at least schedule. It has nothing to do with her schedule. Nothing to do. She's asking that her daughter, if she gets to that point, and I'm saying, yes, when you get to that point, the daughter can go there. All right. And you can have her ahead of time. If he would rather trade weekends, I'm giving him as many options as I can. If he'd rather trade the weekends, then that's fine, because he might rather, because maybe his family thing or something would be on a different weekend. I don't care. I'm giving her the option that, yes, if the child drops out of dance, then there is no issue. None whatsoever.
Well, but as it stands right now, is she's making these claims that it's going to fall on his time. She didn't ask him 50 times. What she did is she sent him 2 emails.
She doesn't, when she sees that this recital is going to appear on, I mean, everybody can figure out when his weekend is. I don't find it so offensive that that she doesn't think they're going to reach an agreement. She comes in and this old man who doesn't have a 3.5-year-old child and all that kind of stuff has to make that decision.
I understand that, Your Honor.
But I will allow her to.
Well, that's why Miss Bryan should pick up the phone or an email or talk to me. I've heard nothing, no negotiations, just go to court. And
nothing
that she's so confident that she's going to get whatever she wants.
I can't force, Mr. Gordon, I can't.
May I at least present my argument, please? I mean, I understand what your ruling is.
I've got 25 motions today.
I understand.
So that's
but the bottom line is the message you're sending is, again, my client is unreasonable because he wants his parenting time.
I didn't say he was unreasonable.
Wants to do, whether it's on his parenting time or her parenting time, she can do whatever it is she wants to do.
No,
so
she can't.
I would
ask
for the same thing.
The court for permission.
I would ask for the same thing. I would ask for the same. I would ask for the same thing in return for my client.
It applies to both of them equally.
On her time, that he's allowed to commandeer her time. It has to be fair, Your Honor. That's all we're asking for.
I'm not saying it's not fair. And I'm saying this is one issue. If he has an issue on her parenting time and he wants to come to court and ask for it, he can come, or he can negotiate with her. He can do whatever he wants.
He doesn't want to go to court. He wants to go to a parenting coordinator and work through our family wizard and not deal with. She asked him 2 times in a span of 3 days. He didn't respond fast enough. So she files a motion. Now it costs him $1,500. It's just crazy. And so basically what she's learning is, yes, file a motion and
I'm not even sure what you want,
whatever you want.
Gordon. I'm not even sure.
Not fair. So, but I understand your ruling, Your Honor. It's just not fair.
The ruling is do you want till Monday to talk to your client to determine if he'd like to exchange weekends, or or not?
Well, again,
Issue the order then, Ms. Bryant.
you can
I
issue
have
the
said
order
that the
and
child
we'll
can
have to talk.
attend there, that the child will be there at least an hour in advance so that mother can, I don't know, prep her?
Yes.
Well, Your Honor, I don't even think the mother has to prep her. There are other teachers. Father can take the child to dance, just
Father
like
can
mommy
take
can
the
take the
child
child
to
to
dance,
dance.
mother can do her hair or whatever an hour beforehand. Father
Who
can
says
stay
mommy
for
has
the
to do
whole
her hair?
recital and be there and watch everything.
Okay.
And at the end of the recital, the child will
It's not
return to
fair
father.
that his time is dealt with. She can handle and do whatever she wants on his time.
Ms.
And that's
Bryant,
not
you
what
understand
we
the order?
settled. What
I do,
Jim
Your
Taylor
Honor. Do you
at
also want
arbitration.
me, excuse me, Brian, do you also want me to include the language that he has until Monday to,
No,
just
I'm
whenever.
not asking for it.
Okay, all right,
You
then
guys want to
that's,
talk about something later? I don't care.
okay, I'll prepare the order. Thank you very much.
So Judge, just to clarify, can you be specific as to what the order is on the second part? So I understand it.
That the child will be presented at the recital. Is it just a 1-day recital?
Yeah.
That the child will be
Sometimes they're more than 1 day.
at least an hour before. The mother may assist in the, or whatever, I don't know what you call it. Putting her in a costume or doing her hair or whatever.
Right.
We'll have an hour's time with her to help her prepare for it. At the end of the recital, the child goes back to dad.
Right.
Okay, thank you.
Everyone. Thank you.
Thank you, Your Honor. I'll prepare it.
Good morning.
Steph, I thought I got rid of you earlier.
I thought I got rid of you too.
All right, we have Wingear versus Clarita. Both parties are present on via Zoom. Their respective attorneys are present. That is Ms. Curlis on behalf of, let me get it right, the defendant father, and Ms. Steffes on behalf of the plaintiff mother. This is dad's motion for change of domicile and to modify travel and all kinds of stuff here. The bottom line is mother got an order back in August of 22 that allowed her to change the domicile of the children to Arizona. And she has, and there's a custody parenting time thing that allows for transportation back here that she has to pay for. Now father has decided to move to Sebring, Florida. And the question, I mean, does mother object to him moving to Florida? And do I need a domicile hearing? Because this is going to go pretty straightforward if you're going to ask for a domicile hearing.
Yeah, no, I don't, correct me if I'm wrong, Michelle, I don't believe that she objects necessarily to him changing the domicile to Florida. However, obviously the issue regarding then the travel expenses is much different, as my client has demonstrated in our response to that motion.
I understand that. Hold on.
Yeah.
So, all right. So Ms. Curlis, your client can move to Florida.
Thank you, Your Honor.
And the same parenting time that's in that other order remains in effect. I mean, he gets, I think, a majority of the summer and this kind of stuff. Everything remains the same because the kids are going to school in Arizona and that kind of stuff. The only question is the transportation costs. And my feeling is that the mother had to transport to Grand Rapids because that was the agreement. I think it's appropriate that each party pays 50% for the kids' costs to go to Florida because they're no longer coming here. And that was the agreement. And normally that'd be the cost. That's my thought. You can each give a few moments, but it's going to be hard to change it. Go ahead. Ms. Curlis.
Regarding the plaintiff's response to our motion, the parties did do their mediation regarding the change of domicile for Ms. Apagani to change to Arizona. They stated in their response that they, quote, reached the agreement with the understanding that the defendant, Mr. Claretta, would incorporate time for the children with their friends and family.
Nothing in that order about it. That's just negotiation.
That's right.
I don't care to hear about it.
Okay. All right. The only issue here, as you know, is the cost of the flights. When I did do a comparison, Judge, there is not much change in the flight cost at all. It was also pointed out that Mr. Claretta did take a small pay cut for a better work environment, family environment, and he's not asking for a reduction in child support. And that's why we believe that the cost provision should remain the same, since really nothing has changed except the airport pick up and drop off. So we would ask that the current order be continue to stay in place relative to travel costs, just that the location pickups change from Grand Rapids to either Sarasota, Florida, or Punta Gorda, Florida.
But I'm telling you that as long as the kids lived here and he allowed them to move down there, that's fine. Once these parties are moving all over, then they can pay for half of the cost. They can work together and pay for the children only cost for the transportation. That's just basic fairness to me. He moved, when she moved, she had to pay. He's moved now, so quite honestly, he should have to pay, but both of them have moved, so they're each gonna pay. That's,
Okay.
you can, they gotta work together, find decent prices and send the kids, and that's it. They're responsible to pay for half of the kids' costs. These kids are getting older, 14 and 12, they'll probably, before next summer, they'll probably be 15 and 13, and they can start to fly without much parental guidance, quite frankly, but they'll figure it out, and then they're each responsible for one half. I'm not gonna let one parent charge a whole bunch of money and say, these are kids are gonna go first class and you gotta pay for half of it. Better work together and decide good fees on a decent airplane that goes back and forth between them. That's all it is.
Your Honor, could I make a suggestion so there's not an issue down the road relative to this, the party splitting the costs? Could we maybe put a provision in there that states that they need to coordinate maybe 30 days before the scheduled visitation regarding the flight schedules, and that plaintiff would pay the kids from flying from Mesa or Phoenix to Florida, and then defendant would pay for the kids to then go back to mom. The airports maybe need to be used of Mesa or Phoenix, and then Punta Gorda or Sarasota.
That's fine. The parties do have to cooperate. The parties, I'm assuming, are going to buy a round trip ticket probably for the kids, so that, I mean, they should be coordinating at least 30 days in advance, because it gets more expensive the closer you get. These parties should coordinate 60 days in advance for airfare. And they just simply have to get along with it. Whether or not she pays to get him there and he pays, I understand, I know for flying Southwest, okay, that sometimes it's cheaper to fly there and then it costs more to fly back. Whatever it is, they have to coordinate, and each party is responsible for half. If it's cheaper to fly the kids to Florida and it's on her cost or his cost or whichever, but it's more expensive to fly back, doesn't matter. They'll jointly have to pay half. All right. This is, if these parties cannot get along on this, then I've issued the order. You're each going to be responsible for half, and you're each going to do your best to get the kids there in the safest, easiest manner, with, you know, the fewest flight changes and everything you can do. It might be you have to pay a little more because they fly direct or something, but work together. You must work together. Do you understand that, both of you?
Yes.
Yes, sir.
That'll be the court order.
Understood.
If I may, Your Honor.
What?
I think it would be easier for both of us if, like my attorney suggested, if Michelle were to pay from Arizona to Florida, and I were to pay from Florida to no matter what the cost, it just, then we don't have to exchange money. I don't have to send her money. She doesn't have to send me money.
Both of you are responsible for half. All right. And you ought to be able to figure this out, whether or not you're both responsible for the cost of the children getting back and forth. All right. And it'll be split, and you can figure out how to split it. It should be really close and all that kind of stuff. So if you can agree between the two of you, that's fine. But in essence, both of you are responsible for half of the cost. All right.
Okay. Then.
Thank you.
Can we at least agree that we need to coordinate at least 60 days prior to travel?
Yeah, you guys got, that's the best.
I think that seems reasonable.
Yeah.
You know, barring unforeseen circumstances, of course. I think that makes some sense.
Yeah, barring COVID-19 that shuts down airplanes or something like that.
Right.
But quite honestly, you should get on it. You should be looking at summer transportation pretty soon to make sure you get the best price at the correct time and stuff like that. Just coordinate. You guys don't have to like each other, but this is the order of the court. You got to coordinate that sort of stuff at least 60 days in advance. Good luck, everyone. Thank you.
Thank you.
Zelinski versus Zelinski. Both parties are present via Zoom. Mr. Haslam representing the plaintiff, Mr. Scott representing the defendant. This is a motion that it's regarding 2-year-old Jack, I think, and a motion regarding holiday parenting time. Mr. Zelinski is, as I understand it, and I got to ask this question, is he in phase 3?
He is, Your Honor.
All right, because I understand the phases that have gone all the way through here. He is in phase 3. When did he get in phase 3?
I believe about a month ago. Is that correct, Mr. Zelinski?
Yes, September 1st.
So basically, as I understood, the first 2 months, you still have to have your mother present during the parenting time. Is that correct?
That's correct.
And then after that, it goes off into regular parenting time. That's
Yes,
right. All right. And I know you're asking for it to also include Christmas and stuff like that per the Ottawa County schedule. Does that pretty much say it, Mr. Scott?
The only slight modification, Your Honor, you did a good job summing it up. Obviously, we just want the judgment of divorce terms enforced. It's crystal clear. They've already mediated this. They already agreed to this. Mom apparently has some reservations. She didn't file a motion about whatever her unspoken reservations are. The order is, again, crystal clear. Once he's in phase 3, he gets this Ottawa County
It
time.
doesn't appear to be that way, but I'm going to ask Mr. Haslam why he thinks it isn't.
Thank you.
Mr. Haslam, there's pretty clear right in the judgment that he gets.
Thank you, Your Honor. Thank you, Your Honor. The contemplation and understanding, which is why when opposing counsel first came on the case in lieu of Ms. Watt Stay, who I believe did not labor under any misapprehensions or misunderstandings with respect to the holiday time, was that this child is 2 years old and not in school, and therefore there are no school breaks to divide. Mr. Zelinski has enjoyed holiday parenting time in the context of I guess we would call it the prorata time that he has been exercising. He has now recently gone into phase 3. As the court can see, there's actually, I believe, a 2-month requirement, as you observed, that his mother supervised that before he can have these Friday and Saturday overnights, which amounts to 4 overnights per month, Your Honor. And he apparently is interpreting the Ottawa County parenting policy, which speaks in terms of school-age children dividing breaks from school as applying to a 2-year-old.
Mr. Haslam, that's just the guideline that everybody that they're using, and it's really clear in here that the guideline is that he gets X number of days over the Christmas holidays and stuff like that. It's right in the judgment, basically. And it sounds like it's buyer's remorse, but I don't see anything in here that would say, wait a minute, he's got to wait till the kid's 5 years old to get it. There's nothing in here that does that. It basically gives the court the idea that once he reaches a certain phase, he gets this Ottawa County court, holiday parenting time. I think it even says in D over here, for example, if the defendant is exercising parenting time at a phase where supervised, 9 to 5, so the parties agree to exercise holiday parenting time in accordance with the Ottawa County holiday parenting time schedule at such times as the defendant is exercising regular parenting time in accordance with phase 3 above. It does not accept and say, well, the kid's got to be in school or anything like that. The parties will exchange the minor at McDonald's. That to me is as clear as it gets, and that he would get his holiday parenting time according to the Ottawa schedule. That is just a guideline for it. That's what we're following, because in lieu of putting in, and he would get December such to such and such and such, you're using the guidelines. That's just clear to me. The parties have agreed to exercise holiday parenting time in accordance with the Ottawa County holiday parenting time schedule. If it had been stated once the child attains the school age or something like that, it'd be different. There'd be no doubt, but that is in there. And I find that is clear language, and he will start according to Ottawa County schedule. Anything else anybody wants to add?
No, Your Honor, thank you.
Mr. Haslam?
No, Your Honor, other than the understanding from the mediator was at variance with the conclusion, but I understand.
That's in there. So good luck, everybody. Thank you. You can draft the order, Mr. Scott.
Thank you. I will do so, Your Honor.
Good luck, everybody. Thank you. We're adjourned.
Okay, I'm gonna bring up a couple people in to figure out how they are.
DC, matter of Quintanilla versus Rideout. Both parties are present via Zoom. This is the plaintiff, Mr. Quintanilla's motion for a temporary order says that the two children have been with him for a significant period of time. And now suddenly you come by and taken the kids and not allowed him to see the kids. So he's looking for temporary order until we can get some kind of a judgment in a custody case. Does that pretty much say it, sir? How long were the kids with you?
Let me clarify real quick. Sorry. So they've been with me since birth, and me and her have been separated for about 2 years now. But she didn't just take them and didn't give them back. It was like a dispute. I did get them back, and since then she's also had them like again several times. In the paperwork, I had stated that she's like a lot more active in their lives now.
And you said you were glad about that.
Yes, exactly. Like I'm very happy about that. I was just like in that moment, not being able to.
I understand you were mad, so thank you for being a mellow person.
Yeah, not mad. I was more scared. Like when we were having that moment, like I was just thinking like I don't know when I'll get my kids back or anything like that.
Do you guys have you worked out any kind of agreement as to when you'd exchange the kids and stuff like that?
Yeah, so we usually do pretty good at it, and that's what I was trying to say. It's like nothing vindictive. It's just I want to be able to, if anything does happen and she were to try to take them, I just would like to be able to, be able to do something about it instead of just worrying about when I'd be able to see them again or,
I'm
deciding.
sure he wants the same thing. What should we do? We should issue an order giving you both joint legal and physical at this point because you're getting along, okay? What kind of time are you proposing? Do you guys just want to figure out the times you're going to have, or should we?
Yeah, that's usually what we do. Yep. And that's
are you all right with that order?
Sure, except if we do it ourselves, is he actually going to get a hold of me when I'm supposed to come pick up my kids instead of ignoring me and telling me I can come get them? And then I am speaking. Please let me speak. I did not interrupt you. It is my turn. Thank you.
It's my turn for a minute, okay?
Okay.
I'm asking you, do you want specific parenting time, or do the parties want to work together to do this?
I would like specific.
What specific parenting time do you want?
Every other week or every other 2 weeks, a week at a time, and then it can switch back and forth. He just had them for 2 months because I was recovering from a surgery and I could not lift over 10 pounds and I was scared that I would not be able to properly take care of them. So I have had them for 2 weeks now since I was fully healed and was able to go back to work so I could support my children. And he had them for a total of 2 months. So I would appreciate it if I could keep them for the rest of this 2-month time period. And then we could go back and forth.
He was taking care of the kids because you couldn't take care of them. I'm not going to make up that time. That's something that he took care of when the kids were, when you couldn't. As far
He
as
didn't even let
I told her I was fine with
me
that.
speak to my kids. I called him day in and day out, and he never once answered me.
Why don't you guys do a simple thing of you have a week, he has a week, and then you don't have to fight about anything. You exchange on like a Sunday at 8 o'clock at night, or 6 o'clock at night, and then you guys don't have to fight about anything.
So, if I can interject real quick.
That's what it was supposed to be.
But I told her when she told me that she wanted them for the 2 months, I told her that was fine. So that's nothing that I had a problem with. But the reason why I had said so was just based off like the living space or like the living situation. Like with me, they have their own space. Like we do pretty much live in a studio apartment, but they have their own beds. They
You
have
live in the basement of your mother's house. That's not a studio apartment.
That's why I said pretty much. It's a studio.
Ma'am, do you remember you said you didn't interrupt him?
Yeah. So the only reason why I was saying where they're with me, most of the time was just based off the living situation. I know with her, I believe they all sleep in the same room. And
right, but I don't know what they do, and I don't know how that is. And all I'm saying is the two of you are basically saying a week on, week off works for both of you.
Yeah, for me, it's just to her convenience, honestly. Whenever she's wanted them, I've brought them out. When she lived in Wayland, I brought them to her in Muskegon.
Ma'am, do you want a week on with the kids and then a week off?
Yes.
All right.
But I'd appreciate it if he would stop lying because he would fight with me when I needed the kids.
Stop. I'm talking now, both of you. Both of you. All right. the order will be, who has the kids right now?
I do.
All right. How about you keep them through till next Sunday at 5 o'clock?
Okay.
Or not this
So-
Sunday, but next Sunday. And
Can
then,
I-
then you will, then it will be week on, week off, starting, he will start next Sunday.
Okay.
Right?
Can I interject real quick? Sorry about that.
What do you want to interject?
So I know she had said that she would rather do like the scheduled time, but when she first started talking, she was trying to tell you that she wanted them for the remainder of the time that I had them, which would be like for the 2 months.
Sure. We just,
That
we
I
just
know.
come up with the order.
Yeah, but that's what I was saying. Like, so right now it seems like she might be a little bit upset about the order, and that's why I was saying initially that like we could decide when she wanted them. Because if she were to want to keep them for the rest of that time, that's fine with me.
Here's the problem is you guys are not working really great together, all right? And so we're going to do a week on, week off, exchanges on Sunday. The person getting the children will be responsible to come pick up the child or the children from that person. You get from now till next week, Sunday, ma'am, and then he will do a week, and you'll just keep doing week on, week off. I'm going to refer the matter for child support to the friend of the court and see if there's any that should be paid. I'm not saying there is, but we'll refer it there to see if there's anything. That will take care of it. Will be a joint legal physical, week on, week off, until further order of the court. All right?
Yes, sir.
And that's the order you'll follow. I'm not gonna be there if you guys decide to change it. I'm not gonna look over your shoulder. But
Yeah.
I think the best thing is to settle down and start doing this regularly right now. And that's what she's asking for. You're not asking for it. So that's what I'm ordering there. You should follow through and come up with a final order of custody and figure out whatever it is. This is a temporary order. Good luck to both of you. And like I say, a week from this Sunday, sir, you'll get the kids back. All right?
All right. Thank you.
Good luck, ma'am.
Thank you.
Thank you both. Bye.
Bye.
Yeah, sorry. Give me
Sorry.
1 second. All right, yeah.
Got to remove your hat, sir. Sorry, you're in court.
Oh, no, sorry.
That's the rules.
No, I get it.
All right. This is the case of Arthur versus Murray. And Mr. Arthur filed a motion to stop child support. Mr. Arthur, how did you try to get her information about this?
What do you mean?
Did you mail it to her or something?
Yes, I mailed it to her.
Where did you mail it?
I mailed it to Alpenhorn. She was staying with
Matterhorn?
her brother. I believe it's Alpenhorn.
Well, you got on here Matterhorn.
Yeah,
you get it?
Matterhorn, that's what it was.
All right. And that was the last known address you had for her?
Yeah, she bounces around. That's her brother's house, and that's the last place I knew that she was staying at.
And you sent that to her, what, well over a week ago?
I sent it the day that I filed the motion.
All right, so let me make sure that that's like 2 weeks ago. So that's plenty of time. Did it come back to you?
No.
All right, then I believe that's proper service, and I'm only asking because she is not logged on at all today. You say that you have the kids 100% of the time, but you're still paying child support?
Yes, sir.
Now, are you in arrears or something?
Yes.
But you're obviously gonna ask for child support review because you have the kids all the time.
Yes.
And
Well,
you're-
basically what I went to Megan had a FOC hearing, so I went to that. She didn't show up, so they put out a warrant for her arrest for that. But I was asking them if there's a way for us to basically swap if what I owe her, you guys can take and put towards what she owes me.
Well, I'm trying to figure out the easiest way to do this, all right? I will, I'm gonna send this case to the friend of the court for a child support review, since there's a change of circumstance that you have 100% of the time, okay?
They already know that.
Yeah, well, but they haven't done anything about it recently, I don't think. Did they? Did they?
I mean, she is ordered to pay child support now.
To you?
To me, to her dad, who I believe has her oldest, and then to her other kid's dad, who has her two youngest.
How much is she ordered to pay you?
$437, I believe.
All right. I haven't found that in the orders. When was that came out?
2022, or it might have been this year. No, it was January of last year.
All right, I got an order here that says, are there 4 kids?
Yes.
And I got an order here from December of 2022 that says she's to pay you $458 per month.
Yep, that sounds right.
All right. Let me, you're gonna have to give me a little bit of time. We'll get back to you. I'm gonna see if I can contact a friend of the court to just say, instead of taking money from you, apply her $458 to your arrearages.
Okay.
So that every month because you have $4,000 in arrearages or something, right? Yeah.
I have 30. Yeah, it's just about 4,000.
Yeah.
But her arrears with me are now almost 7,000.
Well, let me do some investigation with a friend of the court. I'll make everything that I can right, because you're not getting, I hate to have you being charged for child support when you've got the kids and she's not paying you and all that kind of stuff. Just if you're with me for a week here until I call the friend of the court and see what I can get, we'll get in touch with you with an appropriate order. All right.
Okay. I appreciate that, sir.
I understand what's going on and I hope I can fix it. All right.
I appreciate it.
All right. If not, we'll call you back in on a later motion and I'll deal with it then. Okay. But I think I can fix it. All right.
Okay. Thank you, sir.
Good luck, sir. Thank you
Yes.
very much. All right.
Thank you.
Did you serve a copy of this motion on the defendant, Mr. Merritt?
I did, and then I haven't got the paper back because he didn't sign anything. He didn't open the door, and then the USPS has it in Cedar Springs, and he hasn't got it yet.
When
I
did
checked.
when did you send it to him?
That was let me see, I have the paper here. I have the,
Looks like back early in October.
18 of October.
Okay, and everybody's attempted to serve him. He just won't answer the door.
Twice already. Yep.
That's enough attempt to serve him, so I'll find that proper service has been attempted at least, and because he's never logged in. This is your motion for a temporary order regarding Levi, who I think is 7.
Correct. Yep.
And you say that Dad's kind of way out there.
Yes,
Has he tried to see his son?
See, the thing is that he asked, to see him and stuff. And then every time I try to let my son go, my son comes with like bad news about him. He's an alcoholic and he smokes and drinks and he uses drugs. He's currently on probation for 3 years and he's just not good for my son. I'm just trying to protect him.
How much does your son see him?
I'm gonna say just like a few times, like, you know what I mean? Like, I'm gonna say like 10 times within 7 years because he's been
7 years?
in and out of jail.
All right. There's a request for a temporary order. I'm going to give you temporary legal and physical custody. Just a minute. And his parenting time will be only as agreed upon, which means if you don't want to agree on it, you don't have to give it to him. He can make a motion to the court to come in and do that. Okay. Because I hate to have you bother to sign up for like Journeys or something if he's not even going to do it. All right. So, so only parenting time that the two of you agree upon. Right.
Okay.
And I would suggest to you, if you do agree to letting him take him for an hour, that you have a written statement that you both signed beforehand. All right. And I'll send it to the friend of the court for child support.
Thank you.
All right. All right.
Thank you.
We'll get an order out on this, but like I say, understand that if you don't agree to the parenting time, he can always come in and ask me for it if he really wants to, and then I'll deal with it. All right.
Yep.
All right. We'll get that order out to you. Thank you very much. Take care. Have a good weekend. Stevens versus Burbank Motts. Both parties are present via Zoom. This is a motion filed by mother to require father to have supervised parenting time. She says the child is returned from his home with a bruise, even though the daughter said it happened at school. She just doesn't know whether it did. Says the daughter, who is 6, says that dad and stepmom or something yell at her. Sometimes she comes home, she's worried. Ma'am, what is it that you think that you have enough evidence here to require supervised parenting time?
Well, sir, I dropped off some things in a mailbox earlier this morning for you. Yesterday.
On the record.
Okay. Yesterday, I received information from her school counselor. I can read the letter quickly to you if you would like. It says Aaliyah Burbank, which is my daughter, is in first grade at Kent City Elementary. In early October, Aaliyah's mother, Jolene Stevens, contacted the school and requested that her daughter speak with a social worker regarding some concerning behaviors that have been increasing in both number and severity. According to mom, Aaliyah has been stealing and lying and become more withdrawn and sad. She reported that Aaliyah had requested on several occasions that she not be required to attend visitations with her dad and his new wife, and that Aaliyah seemed to be struggling with the birth of their new baby. Mom requested accommodations regarding outside counseling services. Aaliyah was seen by the school social worker on 10/9/23 and 10/19/23. Aaliyah presented as open and forthcoming and admitted that she had been taking items that did not belong to her and sometimes lying about events or happenings at home and school. She reported that she lies because she is afraid I might get in trouble and get yelled at and sent to my room. Aaliyah is unsure why she takes items that don't belong to her and simply said it made her feel good to have them. Aaliyah spoke openly about feeling afraid when visiting her dad and expressed that she doesn't think that they like me. When asked who they were, Aaliyah stated, "None in the house." She stated as she had these feelings in the past, but since the new baby came, she feels, and it says, more bad. Aaliyah's teacher reports concerns relating her ability to attend instruction in the classroom. She notes that Aaliyah is often in her own thoughts and expressed concerns of this impacting her ability to maintain focus during instruction. Aaliyah is able to share during class and worries about something happening to me. And sometimes I just start to feel a little sad for no reason. There's recommendations. Aaliyah is a sweet 6-year-old girl who appears to be struggling with recent changes in her relationship, primarily the addition of her father's new baby and the feelings of not belonging. She acts out her fears by lying and stealing and struggles to use the words to express her feelings due to fears saying something wrong or getting in trouble. It would be a benefit for mom to seek outside counseling services for Aaliyah for support with her developing.
All right, so all this comes down to your daughter needs counseling.
No, sir. She has been emotionally withdrawn.
What is dad's parenting time? Sir, what's your parenting time with her?
There is
no current parenting time issued, but we have been practicing every other weekend for the last almost 2 years now. And just recently, I have not been able to see her due to her mother's concerns regarding this situation.
Ma'am, if I'm listening to this independently, almost everything that the counselor gets is information from you. And then
yeah, it was the information that she got from my daughter on 10/9 and 10/19.
I listened to the letter, and most of the background is provided by you. I'm not certain that Dad every other weekend, I mean, he gets every other weekend, and all the problems for your daughter are from that every other weekend. Yeah, you got 12 of 14 days.
It has recently gotten worse in the last month. She is emotionally withdrawing and detaching her feelings from her father because she claims she is getting yelled at and screamed at by both him and the other adult in their household. Since she has been away from them, sir, she has become her normal, happy self again. She's grasping concepts that I mentioned in this letter that have only happened within the last 6 months, because I also have text messages I put in your box too, showing some of the things that I deal with on a regular basis over the years with Mr. Burbank.
All right, I'm gonna give him a chance to respond.
Okay.
Sure. What's your
All
response?
right. So over the past 3 months or so, it's been very sporadic as to when she allows me to see Aaliyah. There's been multiple times now that I've gone to our mutual meeting spot, because I live up in Kingsley and she lives in Cedar Springs. So we've agreed upon a mutual meeting spot in Reed City. And there's been multiple times where my quote end quote scheduled visit between our per se agreed times, there's been multiple in the last 3 months that I've gone to pick Aaliyah up and she doesn't show up. She doesn't text me letting me know that there's no.
Here's the big problem: is there's no parenting time order. So if she doesn't show up, I can't even enforce it.
Exactly.
You
So
haven't asked for a parenting time order.
Not currently, no, I have not. So at this point, my child support issue or order is based on 4 nights a month, every other weekend, and there has been no consistency with that. There's also been a couple times where I have text messages. I can show you them via email or something, but she has withheld Aaliyah from me due to a non-payment issue, which she gets the payment within a couple days.
No matter what you're going to say about this, I can't enforce parenting time that there is no order. So if and when there is a parenting time order, if she withholds parenting time for failing to pay child support, you will file a claim against her and she will lose. Because you cannot do that. But I can't enforce a parenting time order that doesn't exist. So she's asking that you get supervised parenting time. You're asking I get parenting time, but you haven't actually filed for a parenting time order. So I think the best thing that I should do is refer this to the friend of the court for a parenting time order so that they can investigate it and see what's going on. Ma'am, I'm not convinced that he's only entitled to supervised parenting time, and that I mean, this is a 6-year-old child that needs a heritage also. So I'm going to send it to the friend of the court. I'm going to waive your fees. Sir, you're going to have to contact the friend of the court when it comes out. They're going to do an investigation to see what is an appropriate parenting time for you.
Okay.
And then we'll come up with an order. I would hope you're going to have him see his child over the Christmas and the holidays, but I can't enforce that because there is no parenting time order. Okay. But obviously I will take it into consideration if she's just going to withhold it all altogether since you've been getting parenting time. However, I'm going to refer it to the friend of the court for parenting time. All right.
Okay. Thank you very much.
Thank you.
Good luck to both of you. Thank you.
Thank you.
Hello.
Hello.
How are you doing?
Fine, Mr. Vanderwell. You can hear me. Miss Jimmy, can you hear me? Can you hear me?
Yes.
Can you put on your video, please?
Yes.
All right. This is Well versus Jimmy. Both parties are present via Zoom. This is a motion made by mom to change custody. There was a judgment of paternity back in 2022. It granted joint legal and physical custody to mom. With a parenting time addendum, she now says she wants to change custody, which I don't know what you're asking for because you have custody. Obviously, she claims that when the child comes back from parenting time, that the child's hungry and the diapers are wet and the dad has PTSD. So I don't know what you're asking. What do you want to prohibit him because you claim the child's hungry or what? What are you looking for, ma'am?
Yes, like the baby come home and be hungry and the diaper are white.
So what? I shouldn't give him parenting time, you're saying?
I think if you're having like parenting time with me, he do need someone to like supervising with the child with him.
Sir, what is your response?
Judge, if I may, I've never been diagnosed with PTSD. And
even if you are, it doesn't mean you can't have parenting time. So don't.
And right now, I am confused about this, and I feel like this might be an outlet because she's under CPS investigation with the child at the moment.
Is there a CPS investigation, ma'am?
I don't have investigation. I'm only coming to see where my baby lives because he want to call CPS on me for my kid.
And that, my judge, is because I picked him up and he had bruises all over his face and 2 black eyes. And CPS does have documented evidence of that.
All right.
No, excuse me, Josh. He's saying the baby was having bruises all over his face. That was lie. It was just like a mark on my baby face.
I'm not trying that case here. I'm not trying that case here. That is
okay,
good. If CPS investigates and find out something, I'll deal with it at that point. At this point, there is nothing about a proper cause or change of circumstance to enable me to have a custody hearing or even a shade hearing regarding parenting time. And so as a result, I'm going to deny your motion for change of cause, for change of parenting time or custody. There's just nothing here.
The parenting time is not working with my time, with my work schedule. It's not working with my work schedule.
I don't know what you're saying. It doesn't work for you?
Yes, the time and day. It's not working schedule with my job schedule.
I'm telling you, that's the order. You didn't ask that, you modify it some. Mr. Vanderwell, does the parenting time schedule work for you?
Yes, it does.
That'll be the order of the court, that it continues until further order. Good luck, everybody. Thank you, ma'am. Your motion is denied.
Why?
There's no evidence. No evidence to have a custody hearing or a parenting time hearing. Or at least not sufficient. Thank you.
All right. Thank you, Judge.
Thank you. DS Vidal versus Cavazos. Both parties are present via Zoom. This is the plaintiff mother's motion for parenting time. She wants some kind of a specific schedule. Suggests every other weekend, Friday to Sunday, and 1 or 2 evenings a week. Dad's response says he works and can't do a specific schedule and is going to be gone all winter. Sir, what are we supposed to do to have you have some kind of time with your child?
So far, we've been keeping in contact with the times of me picking him up throughout the week, from the time that he gets out and the specified time that we've already talked about, which is about 7:45. I mean, I work with a team of people out here downtown, in the city of Grand Rapids. And yes.
Your hat, please.
Oh, sorry about that.
All right.
Yeah. So, I work with the people downtown, which are my team people that work in my business. And, about those times, I'm usually out from like 7:45 p.m. and I try to stay out at best to like about 4 a.m., 5 a.m. at best to try to make some sort of income doing that.
So, but mom's main thing is she'd like to have some idea of some, straightforward time so that, I mean, otherwise she's just kind of left with, hey, whenever I get there, I get there.
No. I mean, me and her have already discussed also about the times, and even on the weekend, I've been working out so far with meeting her at noon because it does take my time. It does take my son some time to get up and get around, and also them and their family to get up and get around. So roughly about noon is when I've been picking him up, and then I've been keeping him for that same periodic day from the noon all the way to 7:45.
Noon till 7:45 on Saturday?
Yes.
Nothing on Sunday?
I can do it. I'm flexible with the days.
What about, ma'am, what do you seeking here? He says you guys working together, and I understand you want some sort of certainty, and quite frankly, the court has to, if you request certainty in parenting time, I kind of have to do it. But and sir, you said you're gonna be gone all winter.
Through the winter, yes. I'm trying to save. I can stay at best to like, before I want to try to leave I want my son's birthday to go through. I want to be here for my son's birthday and then leave after that, because my business over here, it just thrives also through the summer, so it's consistent. But the winter sets here in Grand Rapids, I have to move over to a warmer spot where it consists over there. So they shut everything down over here, and then I have to move to the warmer areas to keep my workers all busy through the winter. So I follow through with them.
Let me ask Ms. Vidal, what are we supposed to do to try and fix this?
I just want consistency. You know, it's never been consistent. It's always been, you know, him saying, hey, I'll do this day. It's mainly him just telling me what days he's going to take him. I just want consistency. That's why I asked for every other weekend. Adrian goes with him. He hasn't taken Adrian on a Friday night in over a month. Weekends has never been a Saturday and Sunday. It's always been, one day. And then for the noon thing, no, my son does not make up at noon. Adrian's usually up by like 8 o'clock and 9 o'clock. The noon is for Juan because he's out all night working. He doesn't take him for any overnights. I need consistency. I have Adrian 90% of the time. It needs to be consistent. And that's why I requested this.
I know, but he's saying if he can't do every other weekend, okay? If he literally can't do it because of work and I mean, do you want him to take Adrian home and just leave him at home while he goes to work? No. I'm just trying to find out something. I hate to order him to take him because I can't make him take him. Even if I give all weekend, every other weekend, and if he doesn't show up Friday to take him, what? Because he said he has to work. What do I do? I'm trying to.
Well, that's what I'm saying. It goes back to there's no accountability. You know, it's anyone can sit here and say they're working, but how do we really know he's working all night? And here's the other thing. Most people I know that do these situations, it is every other weekend. So I guess I'm not sure why Juan lives with his dad. So there's other people in the home. So I'm not sure why that can't be factored in. I understand that's not his, father's child, but I'm just asking for consistency. Adrian's been living with me solely since he was 2 years old. He's about to be 7. I'm just kind of tired of, it just seems like people get away with things. That's why I'm asking for this, to have consistent in paperwork, in writing. This is when you need to take him.
This is kind of like you're saying that you want him to be a good dad, and he's not necessarily.
I'm not trying to say that, but I'm just saying it needs to be consistent. I mean, if you're wanting to see your child, you're going to make it work to see him. And, being gone for the winter, that's 3 months. I mean, it's like, why can't he take him when he is here every other weekend, a couple of days a week? Again, that's putting all the responsibility on me, not to mention the financial. What I get in child support a month is a joke. I'm actually going to probably request him to look at that too. He pays $130 a month in child support. That's a month. I have my own rent. I have bills. He lives with his dad. I have way more expenses than he does.
Yeah, but we're not here for that. We're here for parenting time right now.
Right now,
But if we were to diminish something like that, I actually do have stuff to talk about that as well.
That's I'm not going to hear that. I'm going to
Understood.
right now. Why can't you take your son every Saturday at 10 o'clock in the morning and return him Sunday at 6 o'clock?
Well, my father's actually willing to work with that to kind of help out. It's just because I'm out here in the conditions, and I'm not going to have my son sleeping out here in the van while I'm sitting here grinding throughout the night. It's not a good place for him to be sleeping.
I understand that. I'm saying though,
Mhm.
your dad, if you got relatives in town that help out some, you don't work Saturday night, do you?
Yeah, I'm not opposed to that at all. He's willing to help out.
You work Saturday nights?
In reality, to be honest, the business downtown here runs 24/7, and I try my best to thrive on that 24/7.
Well, how about every other weekend you take a Saturday night for your son? That's for your son. You got.
Of course, and I'm not opposed to that at all, because throughout the time that even with him, I try to do everything with him so that we can make a moment of it. So I'm not opposed to any of this, and don't get me wrong. And it does sound like that I'm trying to avoid with my son. I love my son to the backbone of the world, like seriously. So I'll do whatever I can to help out, and my father, like I said, he's willing to help out.
How about every other week, Saturday at 10 o'clock in the morning till Sunday at 6 o'clock in the afternoon or in the evening, every other week?
Is there a possibility we can transition that Friday to a Saturday?
What do you mean, Friday? I got you.
From like Friday, okay, so Adrian he doesn't have school on a Saturday, so he'll be Friday. I'll pick him up from school and I'll keep him and then return him back to Saturday.
You mean Saturday night as opposed to Friday night?
Yeah.
Okay, so then
Like
again, you're not-
transition from that, from Friday to Saturday, and then the following week do a Saturday and Sunday.
Every other, so 1 week you would do, like, say for instance, this week, you'd pick them up from school Friday and have them back Saturday night at 6 o'clock.
That'll work.
Next weekend, you would pick him up at 10 in the morning on Saturday and have him back at Sunday at 6 o'clock?
So that means that they would have to meet me at the spot that we've been meeting at so far at 10 o'clock.
I'm just asking you, isn't that what you just told me?
Yes, plenty.
And where do you meet to exchange?
We meet right in the middle, by one, I think it's, an elementary school in between her house and my house.
Is that where you meet, ma'am?
Can we get this referred to like the friend of the court, like a mediator? Because I just don't really like the way this is going right now. I feel like it's being rushed. It's
I'm
not
trying to
really-
have an honest discussion here with you, but it doesn't sound
No,
like
but
it's going in your
rushed.
favor.
It's being rushed, and it's just, I'd rather sit down with somebody.
Why, you think a mediator is gonna help you?
I think if we can sit down and actually have a meeting where it's not being rushed, yes, because I guess I don't understand why this is so complicated. I don't understand why, we're still doing partial weekends, like, oh, 1 day Friday, 1 day Saturday. I don't understand why it can't be a full weekend
I'm
every
just
other
trying to
weekend.
have it rotated, sir. That's all I'm asking. Because I'm pretty sure Adrian would also be keen to also enjoy some time with her on the weekend too.
All right, do you want any evening during the week?
During the week. So like I said, I can do throughout the week with him, and that's from the time that he gets out of school to 7:45. Because he's usually getting ready for bed roughly around like 8 or 9-ish.
So you return the child home on every Wednesday, you'll get the child from after school till whatever, 7:45, at which point you'll have the child back to mom?
Yeah, at the meeting spot.
No, I'm saying at her house.
In reality, I'm also running into a situation also with her new partner, and it's kind of creating inclination for me too to be able to be there in the presence, because he's also contacting me in reference to stay away. So meeting spot would be great. I have text from him, so I can show and prove that. So I'm not too worried.
Yeah, and you also started stuff with people, so let's not lie right now.
That's fine. He's the one who seeked it out. It's fine. But he doesn't need to know that. He knows that I have text to prove that he wanted me to stay away, keep my distance.
My lord. Okay, Juan. Nobody
That's
even
fine.
lives here. I live by myself with my kids, so I don't even know why you've been going there.
It's fine because he also referred to that he's
you go to?
yeah,
What's the name of
it's
it?
fine. Yep. Okay.
What is the spot, ma'am? Where you meet and exchange?
Like this is again all stuff that he set up. I never once even necessarily agreed to it. It's just him having to control everything. We've been meeting at Ottawa Hills because again, he has to control everything. And I've been going along with it just to diffuse the situation. That's why again,
ultimately refer everything to the friend of the court, but it is going to take them some time to do it. My thought is for right now to do every Wednesday night from after school until 7:45 with exchanges at Ottawa Hills. Forget it. I'm just going to refer this parenting time to the friend of the court. Let them figure
That's
it out.
fine.
All right. You're both going to be charged. It's $150 per person to go to the friend of the court.
That's fine. I got it covered.
Ma'am, do you have it?
yeah, I mean, if that's what we have to do, because like I said, I just feel like I'm not blaming anybody, but I just feel like it's being rushed and he's just trying to pick and choose. It's not even being figured out. So that's
Refer everything to the friend of the court for parenting time. It'll take them a little bit of time. I hope you'll work together somewhat in the meantime for some parenting time. The friend of the court will contact you. You're both going to be responsible for $150 fee to the friend of the court to be paid promptly, or they'll just dismiss it and then we'll be right back here and it'll be
Understood.
all right.
Yeah.
And I'll refer a parenting time issue to the friend of the court. You guys can both go in and say everything you want and they'll try and work something out.
okay.
Thank you.
That's what you want too, isn't it, Miss Vidal?
That's fine. Yeah.
All right. I'll send out the referral. You'll get it. Make sure you pay your fees accordingly.
Understood.